Test. Good night's sleep helps a lot.
order this regular, I emphasize regular, hearing of the Colorado Oil and Gas Conservation Commission, December 8th, 2015. Ms. Murphy, have commissioners present?
We do have commissioners present, and I will take roll. Commissioner Allward.
Here.
Commissioner Benton.
Present.
Commissioner Craig.
Here.
Chairman Compton.
Here.
Commissioner Hawkins.
Here.
Commissioner Holton.
Here.
Commissioner King.
Here.
Commissioner Spielman is not present, and Commissioner Wolk is not present.
I see it. Yep, I think we have a quorum.
I agree.
Okay, I've had proceedings of past meetings mailed to you. What's your desire?
We move approval.
Second.
We have a motion to approve and a second. Any discussion? Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, same sign. A report from the Executive Director's Office, Executive Director King.
Thank you, Mr. Chairman. I don't have much. I do want to report, as I'm sure you're all aware, of the rollout of the Colorado Water Plan. It was a remarkable effort on behalf of the state. You could say 10 years in the making, from Russ George's brain to a late November rollout of a comprehensive view of what the state's future looks like relative to water. And we had a great celebration at History Colorado, appropriate place to have such an event. It was, it's water. It's not going to be universally well received, but it was pretty darn well received. I think even people who had problems with some element would agree that the state is better off with this plan and with this vision and with this to-do list than we were before we started this. So real proud of the effort of the CWCB and a couple of folks from my staff who contributed to that. It was a remarkable effort. Over 30,000 public comments, which were all responded to individually. And it's become one of my pet peeves in this job is the federal processes. NEPA creates EISs and EAs that are volumes and volumes thick, and it's become a process for process sake, and I'm convinced not a process that really results in a better product. And for us to be able to set the standard and show how you truly incorporate the public comments into what we're doing, that was probably the most pleasing and proud part of the whole thing. So that was great. The second thing I need to do is apologize and course correct. I've only been doing this 5.5 years. One of these days I'll figure it out. Yesterday, when I made the comments about the timeline going forward, in my head, it was a drafting process that could be done fairly quickly. And as I got out of the fog of the hearing, it became apparent it's not a drafting process. This is a negotiation process, and it will not be turned around in the time frame that I gave. We need to have extensive discussions with stakeholders and see if we can, as we have done previously, forge some meaningful agreements that will allow us to come back to this commission with hopefully a more clear document that has, if not universal approval, at least significant movement in that direction. And so I need to revise and extend the time frame. We need to communicate to the stakeholders that what I said yesterday is not going to be in the best interest of the process. And we will circle back before the holidays and kind of give a revised timetable and what we're looking at. Having said that, we do understand that this commission needs the opportunity to review what ultimately will be the staff recommendation, and the stakeholders need the opportunity to have a meaningful opportunity to comment on that in writing. Mr. Chairman, with that, I'd be glad to answer any questions.
Any questions for Mr. King? Thank you very much. Thank you especially for your efforts on the water plan. A report from the director of the Colorado Oil and Gas Conservation Commission.
Thank you, Mr. Chairman. Actually, since I was living on borrowed time yesterday during the rulemaking, I thought I would try to make up and give that all back to you by saying that I really have nothing of substance to report to you directly today.
It doesn't give you more time on the other side.
There's still negotiations to be had. You just said that. we do have a couple of reports from staff that are on the schedule, and I will defer to those. So unless there are questions, I will stand down.
And we do have a written staff report.
And indeed you do.
Okay, any questions for Mr. Lepore? Hearing none. Okay, I'll just say it. Do the commissioners have any comments?
Just real quickly, if I could, Mr.
Commissioner
Chair, I
Allward.
just wanted to comment on the order of the stack of geology textbooks that's holding up the coffee pot. And I noticed that all the economic minerals was at the bottom.
I saw that about the governor would be proud. He would love to see the geology books being used in an appropriate manner.
I'm looking into the audience and I don't see any commenters. Ms. Murphy? There are no audience comments. I'm sorry, the commissioner comment agenda item has already passed. Okay, consent agenda. We have a lengthy consent agenda as a result of the hard work of staff,
We do.
divided into groups for you. As you have previewed those, do you see any that might be a conflict or problematic in any way? Let us know. Hearing no response, what should we do with this consent agenda?
I think we should move to approve the consent agenda as it stands. This would be, I believe, items A through T, not the enforcement agenda items, because I think we treat those separately.
Okay.
Second.
We have a motion and a second or two. Any further discussion? Those in favor of approving the consent agenda items A through T indicate by saying aye.
Aye.
Opposed, nay. Then the consent agenda stands approved. Enforcement matters. What should we do there? Shall we just go ahead and see if the commission would like to approve those, or?
So move approval of enforcement matters group A and B.
Second.
We have a motion and a second to approve the enforcement matters, Group A and Group B. Those in favor indicate by saying aye. Opposed, nay. Enforcement matters stand approved. Now, do we need to take a break until 10, or are we okay? Okay, inactive well bonding audit update. Ms. Danziger.
Since we've raced through this so quickly, yep, we're grabbing the appropriate staff since we're 50 minutes early.
That would be a little, I can understand they wouldn't be quite ready because it would be a little bit of a surprise.
9, 10, 10 o'clock. This doesn't become your time either, does it?
Oh, come on. Sent to you on December 4th. Yes. You want me to forward it to you? I can forward it to you right now. Basically.
By the time you get yourself all organized.
No kidding, you'll be done. Back up. Hi, I thought maybe they're having more rulemaking in the car.
Were we supposed to tell you about that?
Oh, yeah.
You're ready to give us the funnies, right?
I am.
Yeah, I didn't. We got the next one, Thomas Spring, but I don't recall seeing this one in my packet.
There was just a little thing about it. It's just going to be an update,
Yeah, okay.
report on
Okay.
what's going on. Yeah.
Ms. Stanzik, Ms. Ramos, we are ready whenever you are.
Okay. I'm Martha Ramos, Financial Assurance Supervisor for COGCC. Today we'll be presenting Rule 707, excessive inactive wells, additional bonding, and a result of an audit of 2015. All operators are required to have a plugging bond per Rule 707 to ensure the protection of soil, the proper plugging and abandonment of wells, and site reclamation. The bond ensures that the operator is financially capable of fulfilling all the obligations of the Act and the rules. The bond protects the state from financial risk. Rule 706 determines the financial assurance requirements. The operator has options of securing individual bonds per well or statewide blanket bonds. A well that is less than 3,000 feet in total measured depth requires a $10,000 bond per well. Wells greater than or less than 3,000 feet in total measured depth require a $20,000 bond per well. A $60,000 bond will cover 99 wells. A $100,000 bond will cover 100 or more wells. Wells that are not producing or selling products are not generating revenue and are subject to Rule 707, inactive wells. Rule 707 eliminates the potential risk of inactive wells by requiring additional bonding when an operator has too many inactive wells. Rule 707 states that an operator with inactive well count that exceeds the operator's financial assurance, such wells shall be considered excessive inactive wells. Each excessive inactive well is required additional bonding as required per Rule 706. What is an inactive well? The 100 Rule Series defines an inactive well as a shut-in well that is not selling products for 12 consecutive months. Wells that are temporarily abandoned for 6 consecutive months. Injection wells that are not in use for 12 consecutive months. These wells are not generating revenue. Here is an example of how the financial assurance unit determines the bond amount for excessive inactive wells. In this particular case, the operator has 9 inactive wells, 5 where the total measured depth is less than 3,000 feet and requires a $10,000 financial assurance per well or $50,000. 4 of these wells are greater than 3,000 feet in total measured depth and require a $20,000 bond per well or $80,000. The financial assurance in this case is $130,000 for inactive wells. The operator has a blanket bond of $60,000. The financial assurance requirement for the inactive wells is greater than the operator's blanket bond. Therefore, the operator must increase the plugging bond by $70,000. The financial assurance staff conducts ongoing reviews of Colorado operators for compliance for Rule 707. If the analysis determines an operator has excessive inactive wells, a warning letter is sent out. If the operator fails to respond to the warning letter, then that would result in an NOAV, Notice of Alleged Violation. The 2015 financial assurance audit for excessive inactive well consisted of 109 operators reviewed to date. 75 operators were found to be in compliance. 34 warning letters were issued. 6 NOAVs were issued, and 1 bond was claimed upon the operators filing of bankruptcy. 23 operators have been brought into compliance to date, and 3 variance requests are in process. A total of $2,370,000 has been secured for additional financial insurance for plugging and reclamation.
Ms. Ramos, would you entertain a question or two as you proceed, or would you rather we wait until you're through?
I would rather that we wait.
Yes, ma'am.
Okay, thank you.
That's a good decision. You're banking on my poor memory again.
So NOAVs issued for 2015 for Rule 706, there was a total of 6 NOAVs issued. 2 NOAVs were resolved through an AOC for additional bonding and a compliance plan. 2 NOAVs are currently being resolved by the enforcement staff. 1 operator attained compliance through sales and plugging. 1 bond was claimed after the operator's bankruptcy filing. 3 other operators have submitted variance requests with compliance plans. 2 plans have been approved by COGCC staff, and the operator is working towards completion of the work. 1 plan is being reviewed by COGCC staff. Rule 707A states that an operator's financial assurance requirement may be modified or waived if a compliance plan is accepted and approved by COGCC. The operators present their plan to COGCC staff members that include the financial assurance unit supervisor, the engineering unit manager, and engineering area supervisor, and enforcement staff. Requests for a variance to Rule 707 must be submitted before the warning letter deadline. The plan reduces the operator's inactive well count by returning wells to production for sales of product from the well and plugging and abandoning wells. The plan accomplishes all the work on an acceptable schedule. Thank you. Are there any questions?
Thank you, Ms. Ramos. Do you have, or maybe the engineer has an idea of what reasons for you indicated there were 3 variance requests.
Mm-hmm.
What sorts of reasons are being offered for that?
Well, the variance requests were submitted prior to the warning letter deadline, and 1 is still pending. 1 is actually they plan on coming into compliance like in a short period of time. 1 was like in 4 months, and the other one was like in 6 months.
Okay. Second question, total well depth, is that as measured from the surface to the bottom hole, or is that the total length of the bore?
It's the total length of the wellbore. It's measured depth.
Thank you. Any questions, commissioners? Commissioner Craig.
On these compliance requests, do you look at the financial viability of the firm before you give them a waiver? I'm just worried that some of these firms, particularly in this environment, may have other problems developing.
Yes, that is considered their financial capability of complying with the plan.
Can I elaborate?
Director,
Thank you, Mr. Chairman. I want to add a little color, and if I get the colors wrong, then Ms. Stanzik will correct me. In most cases, when an operator asks for a variance from this, it's a variance to pay something less than the total calculated 20,000 times the inactive number of wells. And they present that as, as a plan that we'll pay a big chunk, but we're going to bring other wells onto production. We're going to P&A some wells. So we're going to reduce that number of inactive wells one way or another. We're going to pay you some. We might have to pay you over time, but that's typically the request from the variance. It's not like, don't make us comply. It's we need a plan. We have 80 wells or 120 wells. We somehow didn't realize we were supposed to be keeping up with the inactive well bonding, so now we have a plan. So that's sort of a typical scenario for the variance requests that Martha and Jane deal with.
Stanzik.
And if I could just add one point, that Martha, her presentation showed that the engineering group is involved in the review of the plan. And so one of the requirements of the plan is to, that the operator has to have identified that there aren't any potential risks, environmental risks. The engineers look at MIT compliance. So we didn't, Martha didn't include, because I asked her to take it out, there's like 12, there are like 12 things that are considered that are required for the initial submittal of a proposed plan. And some of that, like you stated, is the financial viability of the company. The costs, if they say they're going to plug a number of wells, they tell us how much it's going to cost to plug them, things like that. But there's always a risk evaluation in terms of environmental risk and then risk of wellbore integrity, things like that. So it's a really comprehensive plan and a comprehensive review.
Thank you. One final opportunity to ask a
Oh.
question.
The director would like me to bring in one piece. So the review of operators' financial assurance with respect to excess inactive wells is just a standard routine part of what Martha and her group does year to year, day to day. But in the spring, the engineering group, Stuart, working with Deputy Director Coleman, Stuart Ellsworth, engineering manager, they looked at all the operators and they came up with a set of criteria that they used to evaluate the risk of operators. As oil prices were dropping and, the concern is, well, operators are going to go out of business. They're not going to be able to uphold their obligations. And so they looked at all of our active operators in the state and ranked them. And so Martha's initial audit, then, instead of conducting it as they've typically done it, just in conjunction with other work, they looked at that list and just went down the list. And Martha's statistics showing that to date, they've reviewed 109 operators. They're just continuing down that list. The good thing was, using the criteria of that ranking, there were some operators that looked to be at high risk, but in their audit, it turned out that they had adequate financial assurance. As Martha pointed out, that 75% of the audited operators are fine. They were in compliance with Rule 707. But then they've identified others that weren't, and so they have been contacted and they're working through it. And I think the great part of the story is the amount of additional financial assurance that's been secured as a result of the audit, the 2.3 million. So that reduces the risk to the state. So it's been a very successful project, and just will be continuing. And when she gets to the bottom of the list, she'll just start at the top and go through again.
Well, thank you very much for your hard work. That's my judgment, a very important part of what you do for the people of the state of Colorado. Thank you.
Thank you.
Okay. Apparently, my colleagues have no questions, so if the director will let you.
Thank you very much.
Okay, Thomas Spring Reclamation Update. Mr. Gowan, Ms. Arthur, and Mr. Costa.
Chairman, we actually had somebody sign up for public comment.
We did.
We did after. I mean, we moved through the beginning items so quickly. And so I wanted to bring that to your attention and wondered what order you would prefer to take that. We could take it after the Thomas Spring update or before.
If it's okay with you all, maybe we'll take the public comment now. I apologize for that. But after the compelling argument that Mr. Murphy presented, I don't know how we could.
It's quite verbose.
Loquacious.
Okay, the public comment is from
Jerry Shepherd.
Ms. Shepherd.
Good morning.
Good morning.
My name is Jerry Shepherd. I live on 1713 Fairacre Road. I am a homeowner who got one of those notices. I was looking at a couple of things, and frankly, there are some concerns I have. One thing to note is, as I was driving down here, they had a thing on the radio that oil is now less than $40 a barrel. So that causes me to wonder, are they going to put us through all this rigmarole? And it ends up that when oil prices drop, that some operators go belly up, and we, the landowners and taxpayers, get left holding the bag. And there is precedent for that in this state, unfortunately. All you have to do is look at the Summitville mine disaster and other disasters in this state. I would incorporate some of the concerns that were noted by people in yesterday's hearing. I wasn't able to stay for the whole thing. I did look at the statute, and to clarify, I am a non-consenting owner, just to make that clear. Obviously, there are some concerns raised, and this, I understand, it's beyond the scope of this hearing as such, but looking at the state constitution that prohibits special privileges, franchises, and immunities, and I question when you have a situation where, in essence, it's a fait accompli, and that's, I think, knowing and the perception of that in the public has caused many people who have similar concerns to me, who A, can't get off work to come down, and B, feel like, well, we can't beat the system. So they've signed their rights away in probably less than optimal terms. So that's one concern as well. I did look at 3460-116 subparens 7 subparens D. I do concede that I was made offers to lease my minerals, but I've not seen the foundation laid that these offers were reasonable under no less favorable conditions than others would be made under similar circumstances. I think that's a foundational thing that has to be met and complied with before we're even talking about a forced pooling. So I would ask that this commission proceed carefully, not just for me who managed to have a schedule where I can get down, I'm semi-retired, but for other folks who couldn't get down here, for other folks who are going, what the heck does this mean? All this paperwork, all this gobbledygook. So I'm not, in essence, saying that we shouldn't have an oil and gas industry, but I would rather have a relationship to our friends in the extractive industries other than that of drug addict and pusher. Thank you very much for your time, and you take care.
Thank you very much for your comments. Okay. Mr. Gowan, if you can regather your crew.
Okay, for the record, this is Peter Gowan. I'm the enforcement supervisor for the commission. At the last meeting, Commissioner Allward requested an update on the compliance schedule of the Thomas L. Spring LLC regarding requirements under Order 1V-437, which is approved by this commission on October 28, 2013. So first, I will provide a procedural history of the case that will explain three things. What happened before the OFE hearing, what the OFE order required, and then third, what's happened since. And then second, I will provide a summary assessment of where we are today. And then third, the staff will do a short presentation, and we can take questions anytime that you have them. So procedural history. It was on September 10, 1996 that the operator became the operator of record of the subject well. In November 13, 2008, the well was plugged. And then on May 28, 2013, the inspection staff, as a result of a complaint by the surface owner, went out and observed the site, and they found that the site did not meet the reclamation standards. So again, that was May of 2013. In June 2013, a notice of alleged violation was issued to the operator. It alleged two violations. One was a 10-day violation of Rule 324 Big A, Little A, based on a failure to take adequate precautions to prevent soil erosion, resulting in adverse impact to the soil and impairment of the ability of the site to sustain vegetative cover. The second was a 10-day violation of Rule 1004A based on the operator's failure to complete final reclamation of the site as required by rule. And then on October 28, 2013, the commission heard this matter as an order finding violation. Okay, so the second part, what did the order specify? First of all, this was an order that had been consented to by the operator and staff on every element of the violations except the penalty, so that the hearing was just on the penalty. So the operator was found in violation of both rules. There was a $20,000 penalty, of which $2,000 was payable within 30 days and $18,000 was suspended, depending upon compliance with the order. So the operator was required to consult and contract with a qualified third-party specialist to assess the site and prepare a reclamation plan. Next, the operator had to fence and stabilize the impacted site, and then stabilization of the site would remain a responsibility of the operator until standards were satisfied. Then the operator was required to submit a Form 27, a remediation plan, explaining the proposed reclamation, and then the operator was required to perform all the requirements of the approved Form 27. And then there was a completion date requirement of June 30th, 2014. So, and the operator had ongoing requirements to continue to monitor and to adapt as necessary until the site stabilization and vegetative cover had met standards. Okay, and then one last thing was that the order did specify, or actually the motion approving the order specified that sometime after June 30th, 2014, the commission would review the matter for purposes of determining whether or not the suspended penalty, what should be done with it. Okay, So that's the procedural history up to the order. Since the order, it's been multiple efforts to proceed with the reclamation plan. The first reclamation plan that was submitted was seriously deficient. Staff required resubmittal. The second reclamation plan was approved by staff with additional recommendations of staff, but was not adequately implemented. As of a September 29, 2015 inspection, the site still didn't meet final reclamation standards. After that inspection, staff required a third reclamation plan. This had greater specificity as to what was required by the operator and required certain things to be performed by November 30th, 2015. So what is the current compliance status? There was a field inspection conducted in early December, and all of the requirements of the third reclamation plan had actually been performed. Now, the site still does not have full vegetative cover that is required to pass final reclamation standards. So it doesn't meet those standards yet, but with ongoing monitoring and adaptive management, the site is postured to achieve that result. So that concludes my introduction. At this point, staff has a brief presentation, and they'll be able to answer any questions that you might have.
Good morning, Commission. My name's Margaret Ash. I'm the manager of the Field Inspection Unit for the Colorado Oil and Gas Conservation Commission. We also have Dr. Denise Arthur, who's our reclamation supervisor. Also in the audience is Ryan Costa, who's our reclamation specialist for southeastern Colorado, who's done considerable work out there, and Mike Leonard, who was now is our quality assurance professional, but started as a field inspector in eastern Colorado and has some familiarity with the site. So again, a brief update on a little bit on the site history. So we'll go a little bit over the site history, discuss a little bit of the problems that we had with the various reclamation plans and implementation, current site status, and then a staff recommendation. So as Peter said, Thomas Spring became the operator in 1996. It was for a re-entry of a well that had been drilled in 1992. And these are the location photos submitted with their permit application. And you can see in the upper left, there's a stake. The vegetation had come back to a certain extent. You could still see a two-track going in there. The upper right-hand photo is actually shows the road and the county road. And then at the lower area, another evidence of the well pad, the 1992 well pad. Over the years, we've done a number of inspections. I think up until the compliance enforcement issues, we did 17 or 11 inspections. And 2007, we found some problems. You know, we were providing action required or failure notices, and we were providing comments and direction to stabilize the site, but it was quite the challenge. We received a formal complaint in May of 2013, and we went out there, and the site had again experienced a lack of stabilization, and this is in the sandhills where you get some significant blowouts. And where this person is standing, he's the complainant. That's, I don't know if you remember from the 2013 hearing, that's the artifact or ventifact. It's the drilling mud that was left in the pit, and all the other material has blown away around it. And so, as Peter said, we've had a number of different reclamation plans. We've had 3 formal plans from people that we would consider qualified experts. Before that, we had a number of Form 27s that were submitted that were, as Peter mentioned, deficient. And we've been working with the oil and gas operator quite a bit. And even when we got a plan in place, sometimes it was not implemented effectively. In this case, they wanted to use manure as their mulch, and it was real thin in some places and real thick in others, so it didn't provide the stabilization that you needed. And then follow-up inspections, a lot of times manure, you know, people out in eastern Colorado, it's fairly common, but if you don't have the right source, it can be bring in a significant amount of weeds. So you can see our vegetative transact on the left, or in our site inspection, it's almost all weeds. The reference area on the right, you know, there's actual native vegetation. And the graph on the far right is how we track our vegetative monitoring.
Ms. Ash, is that kosher? What is that?
I believe that's kosher, but we have some experts here that could. Russian thistle and kosher.
Thank you.
And then other areas, this was another plan, another implementation, and they were using some biosolids or biosolve. And again, you know, too thin, too thick, not enough, different issues. They put up a wind fence, but we'll have some photos that'll show a little bit later that it was not designed. I think they thought they needed to design to average wind speed instead of maximum wind speed. So there's the fence on the left in a September inspection. So we went out, again, we were having some problems, weeds, there was minimal germination, and the wind fence wasn't very effective. So we requested another plan, revised plan, and they submitted the plan, but, you know, at this point, we still thought the plan was ineffective. They suggested mostly just monitoring. And again, sort of the plan was for average conditions instead of what's a fairly extreme area. So on this last plan, we provided on October 30th significant comments and recommendations. And then we also attached a letter with formal conditions of approval. And I've just briefly summarized those conditions of approval, 1 through 6. But good news is the operator, we've built a pretty good relationship over the last year, and they've implemented this program. This is there's a new wind fence. They put in a 70% cover of the bare areas that were seeded with this wood straw. It's a registered product. They've hand seeded, and we're requiring, like, the weed management has to kind of be done it can be done with hand, so restrict access, not damage the vegetation and things like that. So the staff recommendation, we would like the order to remain in effect, that suspended penalty stay there until they meet the final reclamation standard, which, you know, might be another year or two. And we want these conditions of approval that we attached to their October 23rd plan to be part of that enforcement.
The control access. I'll take a wild guess. What the surrounding land may be used for grazing.
It's actually been fenced off. That was one of the issues, to keep it being from overgrazed. And then when we go in and do an inspection, we walk in, so we're not damaging anything. And so when they come in and do additional work, they've got to be careful about driving in, bringing heavy equipment or that kind of thing.
And then is Mr. Costa, who's the expert out in that country, I guess, does he have a sense that this has a pretty good chance of actually working?
I think both Mr. Costa and Dr. Arthur have a pretty strong sense that this is going to work. We've been working pretty closely. I think it's been a good project overall, learning, sort of a learning project, but we think we're going to have success. There will be, as Mr. Gowan said, adaptive management. You know, one thing we see is people monitor, but they don't take action once they see that there's no germination or that they see that, you know, there's areas that are being blown. And so you have to not only monitor, but then if things aren't working, then you have to take action. So
y'all decided the hand seeding was preference to a drill, grass drill or whatever, because the drill's going to do more damage than it's going to solve.
Yeah, the areas were, some of the areas were small and tight, so it wouldn't be practical to haul a tractor out there with a big drill. We were trying, there were a couple areas that there was some germination, so therefore we want to avoid those areas. There were areas that were, they needed to remove the weeds first, so there are lots of reasons just to do it by hand anyway. They had lots of weeds along the fence line that would need to be removed by hand, so it didn't blow off onto the surface owner's property, so on and so forth. So it just met the requirement in terms of logistics.
Commissioner Benton.
This area is still more or less a drought area hasn't received adequate rainfall over the last several years.
I don't think that's the case. I think eastern Colorado went out of the, at least went out of the unprecedented drought, and they have been receiving moisture.
It's not currently then under a drought designation, but
I don't think so. We can look that up, but it changed dramatically this year, the drought designation for eastern Colorado.
well, let's see. I suspect Dr. Allward may have a comment or question, but I'll just let him decide.
I'm tempted to not have one just to
You-
spite you.
You can't do that.
You're right. I'm weaker than that. Just one question I've got a couple, but one with the level of soil erosion that was visible in those earlier photos. What practices were implemented? Did they recontour? Did they bring soil in? How did they take care of that significant, what looked like a couple feet worth of soil loss?
They mostly just did recontouring. I don't think the sand went very far.
I guess, I'm not at all surprised that it hasn't reached final reclamation standards. It would, I didn't expect it in just a couple years, not to mention 1 year. The only thing I'm kind of disappointed in is I thought we gave them as a commission a very generous amount of time to develop and implement a plan. Initially 6 months, but Commissioner Holton extended that to 9 months before they would be reporting back to us. And the fact that it wasn't reported back to us so that we could weigh in on whether we thought something needed to be changed or if the fine should be called. So that's really why I'm very pleased to have had this report. I'm not at all surprised at the status. I am glad you're keeping an eye on it. I expect that with you guys maintaining vigilance that it will move towards this final reclamation, and I look forward to a further report and when you feel the status has changed significantly. Thank you, Mr. Chair.
You may have to leave your home address for that final report.
I can listen. Yeah.
I appreciate the good work you guys have done out there. I know that's
Thank you very much.
been a long project. And I'm going to ask you probably when you're going to give a report later on relative to reclamation.
Oh,
It-
the other reclamation report?
And I'm going to ask you a question then about how long is perpetuity.
Good thing your counsel's here.
Rulemaking. Think about it,
Adaptive
during the
management.
Rulemaking.
Adaptive management. Thank you very much. We appreciate that. Excellent work. In many, you're absolutely right, in many cases, that's it. Well, what should we do, Ms. Murphy? We're so far ahead.
Chairman, I see a couple of options. We could all take a nap for an hour. Um, Seems most popular. I also would wonder if maybe we could move this afternoon's 1:30 presentation about the reclamation report. Take a brief break now and then hear the reclamation report. Listen, I can manage time.
We let you go.
Okay, that's okay with my colleagues. I think we'll take about a
15?
15-minute break while Ms. Ash and Dr. Arthur get set up, and we'll reconvene. reclamation report. And Director Lepore seems to be the lead here.
Thank you, Mr. Chairman. I'm not the lead whatsoever, except to apologize somewhat on behalf of myself. We are in the process of making copies right now of the written reclamation report, which we will hand out to you and encourage you to read over the lunch hour or at your convenience as you see fit. But we had intended to get it to you ahead of this meeting. The fact that you don't have it is my fault. I would just insisted on doing a little bit of editing before it got to you and between the rulemaking hearing yesterday and whatnot. I thought we sort of got it final, I think, on Sunday, and it was my failure to get it into your hands. So it is going to be distributed to you momentarily, and then I will turn this over to Margaret and Denise, who know all about the substance forwards and backwards.
Now, Director, what do you want us to do with that report besides read it?
I think I want you to read it, and then if you have questions, comments, et cetera, we could schedule time at the next hearing, or you can call me or one of these fine women, whatever seems to make the most sense for you. But we'd be happy to come back next hearing and
So we'll have,
respond to some of
we'll
those.
have that copy before we leave today.
You will.
And then if one or two or several of us would like a little more public discussion, we'll arrange that through you.
Absolutely.
Thank you, sir. Well, good morning, Ms. Ashe.
Good morning, Chairman Compton. Again. So again, for the record, Margaret Ashe. I'm the manager of the Field Inspection Unit for the Colorado Oil and Gas Conservation Commission. Also, Dr. Denise Arthur, our reclamation supervisor, and we also have Mike Leonard, our quality assurance professional, who helped us with quite a bit of the data analysis. So this is a brief overview of our final reclamation report that we were directed to prepare by the commission during the May 2015 hearing. So today we're going to talk a little bit about some data review. Some of this data you saw in the September preliminary report, but we have some additional data. We've gone through since September and done a more detailed analysis of our rules, which has identified some opportunities where we think they can be improved, maybe through mostly guidance, hopefully, and then as directed, some recommendations. So in this presentation was sort of built to tie into the report. So when you guys get that, and you'll also have the presentation. So again, just sort of in general, we started out by just finding out how many wells there are that we have jurisdiction over. The database, our COGCC tracks close to 108,000 wells, but some of those are BLM surface, which we don't have the final jurisdiction for reclamation. And then some of those are Indian surface, Indian trust lands, which we don't have jurisdiction on. So within the database, about 98,000 wells that we are responsible for final reclamation. Of those, there are 45,000 that require a final reclamation inspection, and those are wells that are plugged and abandoned, drilled and abandoned, or the status is AL, which is abandoned location. Generally, that means it's an abandoned permit. Now that we have a 2A, it can mean abandoned location, abandoned 2A location. So the good news is over 26,000 of those wells have passed a final reclamation inspection, but that does leave 18,685. And again, these numbers are to July 15th. That's when we finished our queries and started doing the analysis. So maybe a few more at this point. So this 18,685 is sort of our focus. We're going to push to get these wells inspected. And if you break that down, there's 11,900 that are drilled and abandoned and plugged and abandoned. So those are wells we know that were drilled. There was some sort of surface disturbance caused by that activity. And so we're going to have our reclamation specialist focus on those wells. And then the 6,700 plus or minus abandoned locations. Again, because those should be wells that were not drilled, and they might be on active locations where there's producing wells, but they've decided not to drill a well. We're going to have all of the field inspection staff working to identify any issues with the AL status wells. So just sort of a little bit of background on the abandoned location status. We've seen a pretty big increase since 2009. There's probably a lot of different reasons for that. It could be people, we saw a dramatic increase in horizontal wells, so people are abandoning their vertical and directional wells, at least probably in the Wattenberg. And we identified this as an issue while we were doing this project, working on this report. So we started focusing, getting people out to look at these ALs. So since July, we've inspected about 1,400 of these. 1,200 or almost 1,300 have passed, and then we have 101 that have failed. So those are various reasons. Western Colorado, we may have a conductor pipe set, or it may actually have been a disturbed location, and we need to do more work on it. We also went back and looked at the final reclamation for sites that have actually been disturbed. So we went back to March 2014 and we looked at the Form 4s where they're required to tell us when final reclamation is complete, and then we try to schedule an inspection. So of 531 of these that we've inspected, 430 have passed their final reclamation inspection, and 101 have failed. So then we went through a little bit of research on what was the primary reason for failure. And lacking the revegetation standard is generally the most frequently identified problem. We also do find equipment and debris on the site sometimes. Access roads not reclaimed, excess non-noxious weeds. We don't count any weeds when we're doing our vegetation analysis. So, and then other issues like insufficient contouring or erosion. So the analysis of our rules, we spent quite a bit of time looking at our rules. We compared them to 5 other states that are nearby. We also compared them to the BLM. And the analysis shows that our rules are relatively rigorous and comprehensive. We have sufficient detail to lead to successful reclamation, and we have, the staffing, I think, to oversee a fairly rigorous program. But we did find some opportunities where clarification needs to happen. So during the review, we found, were uncertainties, ambiguities, and inconsistent interpretation in some of our rules. And in the report, we've gone through these ambiguities in some detail. We're going to kind of, again, this is a brief overview in this presentation. For the most part, we think we can clarify and provide this consistency through guidance documents that will be developed with stakeholder groups. In some cases, though, some fine-tuning or changes in the rules may be required. So a couple of the things that we're finding that needs clarification: topsoil protection. The surface owner waiver has proven to be extremely complex. Weed management, also an area where there's some need for clarity. One of the things we found is triggers for final reclamation. We have a 2A permit. You can build a location, but our final reclamation rules don't specifically tie into that. They tie more into when a well's being drilled. Monitoring of ongoing.
I'm sorry, Margaret, would you say that again? We have a 2A. Well, you're going to talk more about, I'm sorry.
Yeah, there's another slide on that.
I'll wait.
So topsoil protection, it's in the Oil and Gas Act that we're supposed to protect topsoil. It's a valuable resource. Rule 1001A is pretty clear that operators are required to protect topsoil. But once you get into Rule 1002B, which is our topsoil salvage segregation, it's a little unclear. It seems to apply only if you're excavating topsoil. So what we've been seeing are people that are building directly on it, or they're bringing in fill directly on it. They're not segregating it, or they're moving it off-site. So we're having trouble tracking it. And this building on, and you can have leaks, you can have spills, and you can just have compaction that's going to damage the soil. So it's proven to be an area that's somewhat ambiguous at this point. The surface owner waiver, I think you guys have heard about this a couple of times, but it's proven to be fairly complex. As written, especially on the interim reclamation areas, surface owners are starting to use these areas, and what it does is a lot of times is interfere with revegetation, and it can cause, there can be issues and different things. We've found surface owners basically running industrial operations like wood cutting and gravel operations on basically active well sites in the interim reclamation. So it's proven to be fairly complex issue. The weed management, we're required to implement the Noxious Weed Act, but there are many other types of weeds that don't meet the definition of noxious weeds. Some of them, like kochia, they used to be noxious weeds, but the state and everybody else sort of lost control of them. So now they're not on the Noxious Weed Act, but it's not because they're a desirable species. It's just because it's a fairly complex issue. So,
Margaret, will you entertain a question?
I will.
The state categorizes noxious weeds in three categories.
A, B, and C.
List A, List B, and List C. So when you talk about use that term, you're talking about all three or one or the other? Or?
We are actually talking about all three. Luckily, we look at all three. But then, one of the things we find are these undesirable species like kochia and Russian thistle. In this particular case, this is a hard hat resting on a yardstick, and there's just, it's become debris, and it's sort of stacked up on the location.
We apparently had pretty good rainfall that year.
It was this summer, so yeah, we did.
It's interfering with the reclamation process. So this is early on. It's an early reclamation stage. However, there was little to no germination under most of the areas with this kind of weed management issue.
It's also a safety issue. I mean, this stuff can, a catalytic converter or a hot tailpipe can catch a dry weed on fire.
Lightning.
We've had pumpers in eastern Colorado tell us that it's a wildlife habitat, but probably only for rattlesnakes. I'm not sure. So this is the triggers for commencing reclamation. Rule 1004, it's very clear, once you've drilled and plugged a well, you've got to start final reclamation. But it's very clear for when you've drilled and plugged a well. It is less clear once you've disturbed the land for some other facility, especially now the well pads are frequently remote from the other facilities. And so we've had cases where an operator built a location, they had 4 wells permitted, they abandoned those permits, and then we said, well, you need to do reclamation on that location. They said, no, we have a permit, we don't have to do reclamation. So it's definitely an area of uncertainty and lacks clarity on how it goes forward. So our recommended action plan, 4 parts. We would like to continue to develop our GIS tools and our database tools. I think most people have seen in the with the rest of the field inspection group, we have these really dynamic tools and reports, and on the map layers, it'll show you different statuses of different sites so you can navigate with them. And we're building these for the reclamation group, and we think that's going to help us be a lot more efficient, especially with the, a full staff of 6 people now. We're going to focus on those final reclamation inspections for wells that have been drilled and abandoned, plugged and abandoned. We are going to initiate operator guidance and outreach to try to clarify these rules. And then, if we can't reach some level of clarity, we may recommend some form of rulemaking. But we're going to assess the effectiveness over a period of a year after we've developed and worked with them. And then in the report, you'll see we've started some data management projects. One of them was the AL project. We're trying to work that backlog down. And then we found some other sites where the status is no inspection since, or no record of an inspection. And most of those are older wells. But we found, going through the database, that a lot of times there is actually documentation. We didn't have a formal field inspection report until about 1984. And so prior to that, there's some notes and levels of documentation that say wheat, field in wheat, and other indications that maybe there has been a reclamation inspection. So we're going through those, and we're going to use that information to help us prioritize those older sites.
Questions? Do I get to start, Dr. Allward, or you want to?
Please, we still have time to lunch, right?
Yes. Okay. You indicated there is a problem with some operators sense that they don't have to reclaim where they didn't drill, even though they did disturb the land. And my question is, do you think the rules are sufficiently clear to support your assertion that they do need to do reclamation, or are we going to have to make some adjustments there?
I personally think they're clear, but I can't say that that's something that the rest of industry accepts. So that might be one of those areas where we have to do some fine tuning. Once you disturb land, drilled a well, did this, then you have to reclaim. Or tie it into the Form 2A rules somehow.
So we, the commission, will wait on your lead on that. That's a question. Should this commission wait for your determination of whether or not we do need to go and, heaven forbid, have a rulemaking hearing?
Well, I would recommend that you read the report because there's a lot more detail, and then maybe we provide periodic updates on how things are moving with the guidance and outreach portions.
My next question involves interim reclamation. And you indicated in the report that you're having some difficulty with, and personal disclosure, you totally understand that I do have some parochial interest in agriculture.
I think I remember that, yeah.
So you indicated you're having some difficulty with the landowner utilizing areas of the pad for, I forgot, you said gravel operations or wood chipping or something. You have any thoughts about a solution to that?
I probably don't want to go on record right now.
I understand that.
I think we do have to take a significant look at safety issues. I mean, it's an active oil and gas location probably shouldn't be co-located with another industrial process.
Commissioner Benton.
With respect to that, on a surface owner, help me out, if a surface owner, because you showed one there looked like someone had an antique vehicle collection on one of those pads. If the surface owner says, I'm happy, I want to keep this a gravel pad to store my surplus equipment, and say it happens to be in a convenient spot for that, is that acceptable? And you can say, okay, you signed off on it, we agree, and away you go.
Well, that's part of the ambiguity. And, we have put together a surface owner waiver that sort of explains how that process can work if you're in that area that's should be going through interim reclamation, or maybe has gone through interim reclamation. Vehicles, hay, things like that, though, they can interfere with revegetation. So maybe the surface owner is all right with that. But then, some of the complexities become, one person's junk or treasure is another person's junk, or vice versa. And we've seen people disposing of solid and household waste. And then it's the whole cumulative effect. The Oil and Gas Act in 1994 was revised to say that reclamation of lands disturbed by oil and gas operations was necessary to be protective of public health, safety, welfare, and the environment. So it's a real complex situation.
We'll carry that question over, although your answer may be the same. If we're talking about final reclamation, in your judgment, how much leeway do you have in trying to analyze waiver request on the part of a rancher, for example, that wants to use that pad as is for hay storage or equipment storage or whatever, want to build a shed on it? How much leeway do you feel like you and your staff have to grant that kind of waiver? You understand what I'm trying to ask?
Well, the surface owner variance for final reclamation, it's a variance. It's, again, part of Rule 1001C. And the complexity there is, there's a couple of, one, it says it has to be protective. You can only grant the variance if it's protective of public health, safety, welfare, and the environment. There's not a lot of direction on what that is, especially since the Oil and Gas Act says reclamation is what's necessary to be protective. So we look at each one on an individual basis, and stormwater stabilization of the rest of the locations is really important. And again, we've put together a guidance document working with industry on that. But one of the complexities of that also is we only have tools really to look at individual sites on an individual basis. And in some areas where, a large surface owner, large rancher might have 700 sites, if they ask for 700 variances, the cumulative impacts and wildlife fragmentation is something that will be difficult to assess.
We currently have almost 100 variance requests for the Raton Basin right now.
That are in process, so to speak.
Yeah.
And what form do those take? It's a request to more or less leave the location as is, that it's been essentially reclaimed to the satisfaction of the surface owner, and they said, we're okay, and you don't need to do anything more?
No, that comes in on a Form 4, and there's some guidance in the rule, and then another guidance document. Generally, as is something we don't really accept. There has to be, a reason for it. If you look through the different attorney generals that have been written about this, there has to be something specific. You're asking to leave a pit. You've closed it through 910 standards, but you want to leave it for watering. Or you don't want it completely recontoured. You want it a little bit flat because you're going to use it to feed cattle or access, a road that gives you better access. So they come in all sorts of forms, and then they're supposed to kind of tell us, we're going to do this, this, and this, but we're not going to completely recontour. Or we're going to leave it flat and we're going to, part of it's going to be flat and because we're going to build a hay barn. But then we want to see what's happening on the rest of that. So it's a very time-consuming process because there's no way to standardize it because every location is different. The land use, what the surface owner wants and the surface owner needs, it's kind of hard to standardize it.
In places like Will County, for example, I've seen and actually visited a site or two where there is still a wellhead, but it's like totally surrounded by wheat. I'm understanding you're okay with that. That seems to have worked out for both the operator, the state, and the landowner.
That's a fairly successful interim reclamation project.
Interim.
If the
So when
wellhead's still there, then it's not, it hasn't.
Until they
gone through
P&A
final.
it and put a little more wheat there, it's not done.
Well, I mean, we have had, well, this year we had an incident where the farmer was working the land and disc took out a wellhead. But, so it's, they're getting, productive use of the land is right up to the wellhead, but people have to be careful.
Yeah. So for croplands, yes, that's the case. A lot of times, that you can come right up to the, pretty close to the wellhead. It's, a lot of times they'll have bollards around it so they don't run into it with the tractor. But the challenges come when we've got pasture, rangeland, those kind of issues where the vegetation hasn't come back or isn't coming back. You have erosion issues and so on and so forth. So those are different situations with cropland versus non-cropland.
So what I hear out of that is that if an operator and a surface owner want to do something different with that piece of ground than how it was being used before, let's say it's a drilled and abandoned location, they're going to say, all right, I want to reclaim half of this, fill it in the pit, and I want to use the other half for hay storage or build a barn. That sort of information needs to be on the form when it gets filed to help expedite the process, sort of make it work better for y'all. I wonder where I got that word from. All y'all.
I'm from southern Colorado.
Yeah. I'm from western Colorado.
Say it slower.
Say it a little slower, yeah. Touche. So that's what you're really looking for is more information.
Yes, one of the things that's required is final consultation. The operator's supposed to consult with the landowner, and a lot of that, for timing, you don't want them to start reclaiming the site in the middle of the winter when the ground's frozen, or if there's a crop irrigation or something like that. So during that final consultation, the surface owner has the opportunity to say, well, that road gives me access back into my areas where I never had access, and I would like to use that for cattle feeding. And so, yeah, a lot of information up front, what they're going to do, why the surface owner wants it. And if that all happens up front, they do the consultation and they send in the Form 4, that's fairly helpful. What we do find sometimes is we go out, we do a final reclamation inspection, it fails. Then they send in a Form 4 asking for a surface owner waiver as is. So there's a certain point where that's hard to accept.
You have a difficult job. I appreciate that very much.
Yeah. So what do you do in that case?
Well, in that case, we
let Matt decide.
we direct them to the guidance document, and there's also one of the requirements is an agreement with the surface owner, not necessarily in writing, but that's the best way, and they have to take over responsibility for topsoil protection and reclamation. So sometimes once the surface owner, not that we're going to enforce that once it's become, a non-oil and gas location, but sometimes the surface owners don't always want to agree to that.
Mr. Chair,
Commissioner Allward.
while we're on the variance topic, I'd like to ask a question. And so I pulled up at least a version of Rule 1001C. And it's in a document from the AAG, so I assume it's current and accurate. So it says that to get a variance, the operator has to demonstrate that the variance with the rule, or that compliance with the rule, is not necessary to protect public health, safety, and welfare. So they've got to demonstrate that it's not necessary, but it says demonstrate to the director or the commission's satisfaction. And I've never in my time here seen a variance request of this nature come before the commission. And given how you're talking about how complex some of these issues are, I think that is something that should be brought before the commission, so that we can better understand the complexity of it, and that other stakeholders are aware of some of these issues, so it gets a public airing, so that we have a better sense of the needs, the requirements of different stakeholders, so that we get that input and can work towards solutions for all these stakeholders. So I really think, it should be, if it is this complex, if we're concerned about cumulative impacts, and if our direction is to protect topsoil, that the commission should weigh in on some of these variance requests.
During the work on the guidance document, I think industry would probably tell you that we haven't approved very many of these, to some consternation on their part. And so, but then some of that's because they are complex. We have reported on these variances in the past, the ones that were, state land board was able to provide a, demonstration. There was a rancher in Huerfano County that provided a really good, the whole surface, the final consultation and everything was done really well, and closed some pits under 910, and then kind of made a shallow contour for catching rainwater. But industry would say that there's a huge backlog, and that some of that's because of the complexity. So, maybe if we can't come to terms with it, they do need to come before the commission.
How would the commission find out that there are these requests for variances out there that are outstanding?
Well, some commissioners get a phone call.
I must be on the do not call list.
Yeah, you're on the no call list.
The Form 4s come in, Form 4s are, they're a little harder to track. It's not as easy to track as, like, say, a permit application. I know if one operator, we were discussing a waiver, and I said, I think this is going to be denied. And they said, well, we're going to go to the commission. And I said, fine. I'm happy to see it. And since then, they've done some reclamation.
You're involved, your staff, you and your staff are involved in that final consultation?
We are not part of the final consultation. If we were invited, I think maybe we would go, but I think it's really sort of a private issue. We are going to try to do more outreach to surface owners and other stakeholders, so they understand the rules, they understand what we can do. We've had some people that think they're actually responsible for doing the reclamation, and it's not a cost that the surface owner should have to incur.
No, we do want to verify that the final consultation has occurred, but we don't actually go out and are involved in that final consultation itself. but we want to verify that it's been done.
Is your guidance document in this report, or could we get that under separate cover perhaps?
I believe it might be in one of the appendices. If not, it is on our webpage.
It's Appendix C to the report, and I will send you the report electronically. That I don't think what we handed out, is that included in what we handed out? So the appendices are not included in the handout you got today, but we'll send it to you electronically. And I would recommend that you look at that guidance document, which has taken us months to get drafted with a lot of input from the regulated community, and very genuine effort to highlight the things like writing this on the back of a napkin doesn't grant it, that it's got to be protective of public health, safety, and welfare if the variance is in fact granted. So a lot of effort to try to clarify the procedures and the requirements with an understanding that, again, they're all different and there's no blanket answer to any of this.
Do we need to do something going forward to help clarify? I totally understand. I get it. The position that you're in, trying to follow the act, the regulations. But I am also sympathetic to the landowner, especially the ranching community, farming community, that want to be able to utilize these sites for something. And sometimes it's a little bit vague or unclear how they go about getting that accomplished. And I do know, again, totally get the concept that we do need to protect the soil. We need to, whatever we do, it needs to protect the environment. But I think there's still some vagueness there. Access road. The company, the oil and gas company has maintained that road, and they have berms and water bars, and they're taking care of all that. And then when they leave, their rancher or farmer wants to use that road to access something, it's possible that they're not going to put quite that much effort into the maintenance of that road. And so I don't know exactly how we reach that balance.
Well, an access road on an individual basis is actually fairly simple. It's something you can demonstrate a need for the surface owner. And then, it needs to be stabilized when we do our final inspection, so that the operator needs to have, kept it maintained, some stormwater or vegetated, or, ditches or whatnot. And so on an individual basis, those are fairly easy, and we've approved a number of those. It's really when it's, maybe it's a 4-mile long road and it's part of a whole network of roads. That's where it's really more complex.
Yeah, Commissioner Allward.
So I just wanted to add something to that, Mr. Chair, because as Margaret pointed out, working on the cumulative impacts is rather difficult when you're asked to look at one individual site at a time. And those cumulative impacts are significant. If for example, you care about wheat production, for example. So that it's a recent paper that I just tried to pull up some of the numbers from it, looking at loss of productive land due to oil and gas development in the central states and provinces in North America. And for cropland, the loss is the equivalent of 120 million bushels of wheat production in 12 years. That's 150% of Colorado's average wheat production in just over a decade. We have lost arable land that's now under oil and gas and needs to be reclaimed. And so, that it is significant when you add in all those well pads, roads, compressor sites, and auxiliary facilities, that if we think of just one pad at a time, it's not a big deal. But to lose 150% of Colorado's wheat production per decade, that's starting to add up. And, you know, and this same paper looks at grazing lands in terms of AUMs lost, and as well as, you know, forest lands in terms of national park areas lost, the equivalent thereof. And so it does start to, you know, when you start looking at decades and over large regions, that if we're going to be protective of topsoil, we need to be aggressive, not just reactionary. We've seen what happens when you're not protective of topsoil. I don't think that anybody in this room has actually seen it, but maybe some have with the Dust Bowl, and we ended up with the Soil Conservation Service, the NRCS, in which we recognized that the community has a stake in the topsoil beyond just the individual landowner, and the federal government stepped in. And so we do have an important role to play, and we need to take on that role. And so I commend the staff on their work on this so far and the difficulty of their job. I think some of these difficulties need a public airing so that we're all better. You know, I'm parochial in my concerns mostly about wildlife habitat, and I would like to get a better grasp of how other users want, what their role is in this discussion. And I think the more we can pull people in to help us work on this in good faith, as opposed to just not wanting anything to change, that's important. And so I look forward to reading this document. I look forward to having maybe a little follow-up discussion. I'm a slow learner and I need to read and make notes. I can't grasp everything, even though the graphs help a lot. I really appreciate all the work that's gone into this, but I think we really need to take this seriously and move forward, not in great haste, but deliberately. Thank you, Mr. Chair.
Thank you, Commissioner. Thank you, ladies, for an excellent report. I know it took a little bit of your valuable time to bring this together with your staff, but I think it is a valuable exercise, and Rich is correct. We need to, as best we can, reach a balance, figure out what the best thing for everyone is. But you've done good. Thanks a lot. Any
Thank
other
you.
questions? And you guys awake at all? Or? Okay. Thank you. Appreciate it.
Thank you, Commission.
Thank you.
Hey, Ms. Murphy, I'm at a total loss.
Well, sir, I believe that we're ready to proceed with the enforcement action or the enforcement hearing against Black Resources. My understanding is that Black is present. So unless you would like to delay, I think we can keep cruising.
Sounds like an excellent plan.
And while they get set up, I would like to note that Commissioner Benton has done us all a great service in trying to get the 1 o'clock presenter here at noon. So perhaps we can have a working lunch and
Thank you.
wrap things up after that.
Yay, Commissioner Benton.
It is turned off. I threatened him that he had to drive to work today, so otherwise I would ask him lots of questions. Which he didn't do, so he has to look on the road.
Okay, Black Resources.
Pushing the bounds to say good morning, commissioners, but good morning nonetheless. David Beckstrom, COGCC Enforcement Officer. Together with me at council table, it's Kyle Davenport, Assistant Attorney General. Today, staff brings enforcement action docket number 151000469 against Black Resources Incorporated. And Mr. Black, Bill Black, is the owner and primary for Black Resources and joins us today from Texas. This case arises from violations at Black Resources well, the State 3611 well in Montezuma County, Colorado. Staff is claiming violations of Rules 309, that's Form 7's Operators Monthly Reports of Operations. Rule 319 for violation, the well is temporarily abandoned, and 319 is a violation of failing to submit the annual sundry notice to the commission. And then finally, Rule 326, which is a violation of failing to conduct a timely mechanical integrity test on the temporarily abandoned well. All facts underlying these violations have been stipulated to, that's provided to you in your package. So liability is not the issue here. The issue we have to determine today is what the appropriate penalty and remedy for these violations is. To get to that point, I will do a brief presentation of the case, giving you a little bit of background about the well, the violations themselves, Black Resources compliance with commission rules, and then a recommendation for the commission to consider for a penalty, and a request that you adopt the proposed order. Mr. Davenport will then use whatever time we may have remaining to us to rebut Mr. Black's presentation and arguments, as well as make some closing statements. A little bit about the well. The State 3611 well is a gas well located in the southwest corner of the state. It's operated on a lease with the state of Colorado, and it's located just inside the boundaries of the San Juan National Forest. The well was spudded in November 1989. It was then temporarily abandoned in June 1990 and has not produced since. Black Resources acquired this well and took over as the operator in 1992 and has also not produced the well. A little bit of background with regards to Black Resources compliance with commission rules. If we look back to 2009, staff issued a notice of alleged violation to Black for failure to submit the annual sundry that we require for temporarily abandoned wells. That's Rule 319B. Under 319B, we require that any operator that owns and operates a temporarily abandoned well submit to the commission a report informing the commission how that well is closed to the atmosphere and what plans for future operations the operator has for that well. That's due on an annual basis, and Black failed to do that, resulting in an NOAV in 2009. Also, alleged in that NOAV was a violation of Rule 326 for Black Resources' failure to timely conduct a mechanical integrity test on the temporarily abandoned well. After receiving that NOAV, Black Resources quickly got into compliance with these rules, and per internal policy at the time, that NOAV was withdrawn and no penalty was assessed. However, the issue arises from the fact that Black Resources did not submit any further documentation to the commission between 2009 and June 2015. So in June 2015, staff reviewed the file and issued another notice of alleged violation, this time alleging another violation of Rule 319B for the failure to submit that annual sundry and failure to conduct a timely mechanical integrity test within the 5 years required under Rule 326. In addition, the June 2015 notice of alleged violation included a violation of Rule 309 for Black Resources' failure to submit the Form 7 monthly operations reports required for all wells that are not plugged and abandoned. The first claim made by staff is a violation of Rule 309. This is those Form 7s that we require on a monthly basis. Black Resources, after coming into compliance with the NOAV in 2009, subsequently failed to submit any additional notices of alleged violation between December 2009 and the time the NOAV was issued in June 2015. With that being said, after receiving the NOAV, Black Resources did subsequently submit the delinquent Form 7s on July 2nd, 2015, and is currently in compliance with Rule 309. Commissioner Compton.
So a monthly report
Yes, sir.
between 2009 and 2015, a lot of months.
That is a number of months.
So they have to submit a monthly report for all those months they didn't submit?
Correct. At the time, Black Resources submitted a filing of all months that they had previously missed. And as I mentioned, have also submitted subsequent reports and are currently in compliance with that rule. Yes, Commissioner Benton.
Did the NOAV in 2009, which was also for failure to file monthly report of operations?
The 2009 NOAV did not include a violation of Rule 309, only 319. and
Only
326.
319. Sorry, I wrote that down. Okay.
Any further questions? Yes, Commissioner Hopkins.
The MIT test, was that performed in 2009?
Yes, sir, it was. Black Resources conducted a mechanical integrity test on May 27th, 2009. However, then subsequently failed to conduct the 5-year MIT on the temporarily abandoned well by May 27th, 2014. As I mentioned, the staff also is finding Black in violation or suggesting the commission find Black in violation of Rule 319B. These are the annual sundries. These are due every year that a well is temporarily abandoned, and Black Resources failed to submit these between 2009 and 2015. Again, after receiving the notice of alleged violation, Black did submit a Form 4 sundry on August 31st, 2015, and is in compliance with that rule for at least another year from that day. Yes, Commissioner Benton.
Sorry, I apologize for messing that up earlier. But so 319, they caught up in 2009 on the 319 sundry.
Correct.
Did the NOAV at that time provide a reminder to the operator that said you need to file this sundry on an annual basis?
The rules are clearly stated in that regards. 319 has not changed, and the NOAV does mention that there's an annual requirement for that.
Okay, yeah, I'm aware of the rules. You're supposed to go there and read the rules, but just wanted to sort of help reinforce that by in the NOAV saying you didn't do this and you need to keep doing it,
Correct.
more or less. Okay, thank you.
Of course. Finally, the third claim is a violation of Rule 326C. This is for Black Resources' failure to conduct the 5-year mechanical integrity test on the well. As mentioned earlier, this was due by May 27th, 2014. Again, Black received the notice of alleged violation and then quickly came into compliance again and conducted a successful mechanical integrity test on the well on July 13th, 2015, and submitted the required paperwork for that, and is in compliance with Rule 326C now. As I stated earlier, the facts underlying these violations have been stipulated to by both parties, and the issue then is what the appropriate penalty is. Staff initially calculated a penalty for these violations under the old statute, coming to a total of $30,000. That's $1,000 a day for 10 days for each of the 3 violations. However, during the process of investigating and putting together these enforcement action, staff came to the conclusion that that is not an appropriate penalty in light of the violation and the totality of the circumstances surrounding this case in particular. 2 of the main points that we took into consideration when calculating our final penalty that we would recommend is first that Black, even though he did require a notice of alleged violation, he did quickly come into compliance with those rules and has remained in compliance since. So we considered that. The other factor that we've considered is that Black Resources has worked with the Attorney General's office and established to our satisfaction that Black Resources Incorporated has demonstrated financial distress. So the issue is we have an operator who did get in compliance and has demonstrated financial distress. So when we take those things into consideration, as well as what we believe to be an appropriate penalty as required by statute for these violations, we've come up with a revised calculation for a total penalty of $18,402. This total penalty uses the new statute to calculate rules 309 and 319B in favor of the, in a way most favorable to Black resources. The 309 violation has a penalty of 382 days. It's considered a class 1 minor violation, so a total penalty of $4,165. Rule 319B, also a class 1 minor violation, lasting 442 days for a total penalty of $4,237. The failure to conduct a mechanical integrity test, Rule 326C, we considered under the old statute as it's most favorable to the to Black resources, and is a penalty we believe appropriate for these violations in particular. With that being said, staff recommends a total penalty of $18,402 for this violation. However, we'd like to bring to the Commission's attention the fact that we have had lengthy negotiations with Mr. Black in an attempt to settle this matter in a way that we thought was both fair and equitable and efficient. And to that end, we've made offers that substantially reduced the amount of the total penalty that was due in hard payment. And we also offered a payment plan over the course of a year for that hard penalty. And we suspended a bulk of the penalty pending Black resources compliance with Rules 309 and 319B for a period of 2 years. Staff thought that this is an appropriate response and penalty and remedy in this situation because it takes into account the totality of the circumstances, but also can be used as a tool to encourage continued compliance with the Commission's rules, which is our main objective. With that being said, staff would advocate the consideration of a hard penalty for the MIT violation. The Commission has, on numerous occasions, imposed a penalty between $7,500 and $10,000 under the new old statute for mechanical integrity test, and would also advocate the possibility of a suspension for the rules 309 and 319 pending Black resources continued compliance with those rules. In conclusion, we would ask that the staff, that the Commission find Black resources liable for the 3 violations and adopt a penalty that is appropriate to these violations. Anytime I do have remaining, I would ask to reserve for Mr. Davenport to make rebuttals and closing statements. Thank you.
Okay. Did you have a question, ma'am?
I just want to make sure that I understand this. This well has been shut in for 25 years?
Temporarily abandoned.
Temporarily abandoned?
Correct.
25 years.
Yes, ma'am, that is correct.
I was going to ask that.
And
what is
we are
temporary?
now in a situation, I mean, 1990, you know, that's when I kept hearing about the gas bubble.
Right.
And now we're in a situation where there's so much gas that people don't even know what to do with it anymore. So we could be facing another 25 years of 30, 40 years of temporary abandonment? How long do we allow, I'm sorry, I don't recall, how long do we allow temporary abandonment?
We don't have any rules or policy guiding us in that matter, but Director Lepore will address that.
You asked a question earlier. What does perpetuity mean?
You just didn't know that it was going to apply to this case.
I don't know. Is that something that, I mean, we're okay with that. I mean, work's okay, no problems, as long as we're keeping up with the requirements.
Under our rules, as long as the MIT test is done every 5 years, it can remain temporarily abandoned in perpetuity. Now, just so you know, I mean, other states have different rules, but that's not completely uncommon. As long as the mechanical integrity is tested and established.
Bonding's up to date.
Right. And there's also a reason that we have a requirement for a monthly report and an annual report. So that we understand, so we keep track, simply keeping track of what that well is doing and understanding on a monthly basis. If the
If you give an annual report and say that this is temporarily abandoned, there's nothing to report on a monthly basis, is there?
we do require that those monthly production reports be sent in, and if it's zero production, that's fine. But we want the monthly reports, the production reports. And then the annual reports, they'll probably need staff's help. But, you know, the concept there is, I mean, for example, and I don't know what the details of this well are, but a gas well that far into the hinterlands, you know, maybe there are issues with pipelines getting the gas to market. And, you know, that might be a reason to have a well shut in for a number of years. And that annual report might indicate, you know, compressor station contract signed, pipeline scheduled for completion in 2020.
And I'm just assuming that the MIT test were successfully completed and no problems.
Yes, Commissioner, that is correct. The 2009 and 2015 MIT tests were both successful and approved by COGCC staff.
Any additional questions? We'll go to Mr. Black.
I just have one quick question. The well was drilled 25 years ago. Is the cementing practice the same as it is today? Would it be cemented to surface?
I would have to defer to engineering staff for that, and we do have engineering staff available to answer that question.
Well, I mean, I'm just wondering what kind of risk the well presents, I guess.
Yeah, where'd you run your casing strings? Did you go through, all the way through the necessary formations? I think we ought to get Stuart to make a comment at some point.
Can we ask Mr. Ellsworth to come up and
You know how I like to defer to staff.
First off, what I want to do, Stuart Ellsworth, the engineering manager. First off, I want to give a characterization of what shut-in means and what temporarily abandoned means, because we sometimes get mixed up in that perspective. Shut-in is kind of, I want to pull us back into, let's say, the 1960s before we had air conditioning. Natural gas was used as a supplemental energy source for surging powers, so to speak, during the winter time mostly. And pre-air conditioning, people would shut in their wells, oil and gas wells, for a temporary period of time because they didn't need the extra power. So the concept of shut in is a short-term perspective. The well is still connected to the pipeline. It could still be used. You can switch on a valve or open a gate. Temporarily abandoned implies that it has been disconnected from the pipeline, and it takes a mechanical intervention to turn this well back on, a major effort. So what we try to do is, in that perspective, that's where we ask for the annual update in a sundry to give us an idea of what Director Lepore indicated. What are you going to do to make this a producing well? That is our objective, is for wells to be producing. It's an asset. It needs to be used. So that's the concept of. Then let's twin in the concept of the Carter era perspective of a stripper well. That's where it gets real hard for us to say, this is, as an agency, this is an uneconomic well that's drifting beyond our difficulty, drifting into our regulatory role. So in that sense, what we want to do is maintain mechanical integrity of the well when we use our Bradenhead test, our mechanical integrity test to do that, to make sure we have adequate seals. This was a well drilled in the 90s. So yes, cement technology and such has improved. but I wouldn't consider it a super old well. We're not discussing a 1950s well, but and this is in the southwest corner of the state. I'm trying to look it up as I speak here, so I apologize. But you know, it had a cement bond log, but it is a deep well in that it's not a shallow coal bed methane well and that kind of perspective. So, but I don't believe this well was cemented all the way to the surface. So it has a relatively deep, it's 1,000-foot surface casing, 1,123 feet surface casing, production hole, and the cement goes up to 2,800 feet. So it's grossly, just real quickly here, before you, it seems relatively stout.
So there's the 2,800 feet. So there's 1,700 feet or 1,000 feet of uncemented.
Yes.
Behind production.
Yeah.
Okay, I have questions for Mr. Ellsworth. Thank you very much, sir. Now, I believe it's Mr. Black's turn.
Good morning, Commissioners and Director. I'd like to first get into the background.
If you'll go ahead and introduce yourself for the record.
Yes, sir. Bill Black, President of Black Resources, Inc., a Texas corporation since 1981.
Commissioners, I apologize for interrupting. Mr. Black's not going to be providing any witnesses. However, part of his presentation is going to involve some testimony. So I'd ask that he be sworn in for the portion of his presentation that's going to serve as testimony in this matter.
Can counsel do that?
I can do that. You raise your right hand. Mr. Black, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
We'll just assume the part about your name and company, that's the truth.
Yes, sir. I have been in oil and gas and agriculture business for several decades and owned and operated wells in West Texas and New Mexico, which many of those wells were old stripper wells that Sinclair had drilled as far back as 1937. I thought it was novel since my mother used to work for Sinclair. I found out how novel it was at $8 oil and having to work on these wells all the time. So over the years and having to deal with many different service companies and pumpers in 14 different counties, that I elected to come to this area in southwest Colorado, where I'd acquired some assets from Shell and Arco. And one of those, I had to sign over the operating rights some years back, as Director Lepore would attest to, that Jack Greinberg decided he wanted a shut-in gas well that I had that was in a federal unit. Long and short of it, after 14 years of litigation, just to protect my solid rights in that well, that I was forced to give up operations, which was the backbone of my whole project. So then it left me with some other leases and this particular shut-in well in question. So anyway, that has been a number of years, and Mr. Greinberg has yet to get that well into production. It was drilled in 1983 by Arco. And anyway, with his war chest, still been unable to do what I was looking to do by combining multiple wells and having the volume of justification for this particular project. But after the many years of litigation and whatnot, things changed dramatically. So nonetheless, I'm seeking every possible avenue to put this well into production. As y'all would have noticed, some of the stipulated facts. And these are just a few of the stipulated facts of attempts to put this well in production. It's essentially about 3 miles from the town side of Dolores, where Atmos Energy has a distribution system. And repeatedly, they have denied access to their system. They state they just don't want to take local production. So there obviously is a cause and effect situation here. Granted, it is expensive to build pipelines, but a line of that nature to go to the town site would be within the grasp of reality, as opposed to a dozen miles to such as the Williams Northwest Gas Pipeline. And that's also been a discussion to enter into a tap that they have a dozen miles away. But that entails having to lay pipeline through the city of Dolores and whatnot. So obviously it would be more cost efficient to go to the city of Dolores initially if Atmos would work with us on that. But they have disregarded even a request from the State Land Board Commissioner, Pt1, to do just that. And it would benefit the School Lands Trust and would help us stay alive too. Additionally, other ways include a possible CNG, compressed natural gas supply, for example, to the county at the Dolores bus barn. So I've been in talks with a company that does the CNG installations. And even another possibility is gas to liquids technology that is evolving to convert the natural gas at the well site into transportation fuel. Concerning the late filing of reports, that my ex-wife, who had her own separate career, she was assisting in the filing of reports and such over the years, and I didn't stay on top of it. So I guess I'm being penalized multiple ways on this deal, but had multiple hard drive crashes that created a discombobulation of what had been done, what hadn't been done, and so on and so forth. And over the course of these years and through what Pete Malonis had reported here just recently, that I have paid in $277,000 to the State Land Board for lease bonuses, lease rentals, and shut-in royalties. There have been no revenues received at any point. So I've put in all of the resources that I had from selling off the other production that I had liquid assets to put back into this project. And as it was stated in the stipulated facts, it showed a more than $18,000 loss last year. This year is going to be worse. And I have $19.96 in my company checking account. And for the cost of travel to here, I'm overdrawn personally. So I supported it personally and through everything I had in the corporation to this point. And I'm hoping and praying for a chance of survival through all this to hopefully have some future revenues, because there are no reserves, no IRAs, no pensions. Everything has come right back to this particular area. And anyway, I respectfully request that the expenses incurred just to get here would be sufficient to offset the proposed penalty. And it's acknowledged that there are no adverse conditions existing for environmentally or otherwise. And concerning the reports, the monthly reports, well, there's another thought on that too. I mean, you would have to submit the Form 4 before you put the well in production. And there has been no production other than testing. So that's why it's a constant zero. Unfortunately, I'd love to change that as soon as possible. However, it is what it is. It's stayed the constant zero. So there are no royalties due the state. And if I can preserve my position, it also preserves the Colorado School Land Trust royalties that would be forthcoming from this well. Things that all of that royalty is earmarked for those purposes. So I appreciate y'all's consideration and hope to be allowed to continue to a better day.
Okay, thank you, Mr. Black. If you have some final comments?
Mr. Chairman, staff does not have any questions for Mr. Black. The procedure that's in the final pre-hearing order is that there would be rebuttal, and then Mr. Black would have an opportunity to make a closing statement, and then staff would. If I can make a suggestion, I think if it's acceptable, we can just simply let Mr. Black know that it's his opportunity to make a closing statement, and then staff will, and we can move forward if that's acceptable.
That is acceptable. Any closing statement, Mr. Black?
I don't know. I was explained that this was all rolled into one coming into here, so that's why I said what I did.
Okay. Commissioners have any questions? In
Just one.
review, I'm sorry,
Go
Commissioner
ahead.
Benton.
No.
I was just going to ask for that review. Yet the total penalty sought $18,402. You're suggesting that a portion of that, the reporting shortcoming penalties would be not assessed at this time, provided that Mr. Black's company continues to meet those reporting requirements. Am I right? I'm just guessing here.
Yes, Mr. Chairman, the staff has proposed a penalty of $18,402. That's staff's request to you to issue that penalty. However, staff is not opposed to a suspension of a portion of that penalty, and we request that in that suspension, as part of that suspension, Black Resources be required to comply with Rules 309, 316, and 326, which are the violations in the NOAV for a period of 2 years. However, one of the the commission is required to decide 2 issues today. One is that of liability, and I don't think there's any question about liability here at all today. The other, and this is really the issue that must be decided, is the penalty amount. That is $18,402 is staff's total proposed penalty. Our suggestion and request to you is that a payment of a penalty that is to be due in 30 days, our suggestion in that amount is $7,500 to $10,000. And the reason for that suggestion is because the important issue here is truly the continued compliance with the MIT mechanical integrity testing. And that is a situation that, for whatever reason, Black Resources seem to have found it very difficult to comply with in the past. 2 NOAVs have been issued in the last 6 years. Only after the NOAVs have been issued has the MIT been performed. And the second reason for that amount of the payment of the penalty that payment is due on is because historically that has been the commission's practice, is to issue penalties in the range of $7,500 to $10,000 for those MIT violations under the old statute, which is what staff is requesting. The remainder of that penalty, our suggestion and request, would then be suspended pending compliance.
And then you had indicated a payment plan as a possibility.
A payment plan is certainly a possibility. It was part of discussions with Black Resources and Mr. Black, but we don't necessarily have a definitive statement or suggestion about what that payment plan has to be.
Director Lepore.
Mr. Chairman, if I might just ask staff to tell you what the last settlement offer to Black Resources was, I think that would be helpful information for you to have.
Sure. The last settlement offer to Black Resources was a $5,000 cash payment to be made with a payment plan over a year, and the remainder of the penalty suspended at that point. Mr. Black was unable to accept that offer.
Okay, you commissioners have some thoughts. Difficult.
A difficult situation. Is it, help me understand a little bit about sort of how much you've been able to do or not do with respect to getting the well hooked up. Is it, I don't know anything about the test rates or anything on it. I mean, is it sort of, where's your break-even commercial price on this if you do get it hooked up?
Well, sir, it last tested at 1,643 MCF per day. 4-hour test. However, it would eventually pull down to the range of maybe 300 MCF a day after it's been produced a while, which is still a commercial productive well. I think by old standards, it used to be defined as 90 MCF or better. But anyway, it is a commercially viable well, or else I wouldn't go through all the procedures that I have to, to this date. The economics are there.
Yeah, and the.
May I mention something else?
Sure.
That there was discussion of a payment plan, and the way that's been working out on cash flow that I have some working interest income. It used to be out of Utah, oil and gas production. But now I get bills instead of money. So that's how well that's going. And it's been for a pretty good while now.
Is it some, are you, whether, I guess the Williams line, is that the Williams line that's 12 miles away? Is that correct?
Yes, sir, that's correct.
And the other one's only 3 miles. Have either of those proposed to lay a line and then charge a fee to you, or are they just saying, no, you have to build a line?
And that was a negotiable item with Williams, for example, because they already have an interconnect there, which cost about $1.5 million, either onto Williams or Trans-Colorado, either of the market access. Trans-Colorado is a little bit closer, but the fact that Williams already has the interconnect and operating typically at lower line pressure, but then the offset is having to lay line through the city of Dolores. Alternatively, your question about the Atmos distribution system is it's a low pressure system distributed to the town site, and we would lay that line, or I would have partners to come in and do that. So that would not be on Atmos. We would deliver pipeline quality gas to their particular line, so that there would be no expense as such to Atmos.
What's the cost to do that? Just
Approximately $400,000.
okay. Thank you.
Okay, I'm going to entertain a motion, and it probably should incorporate staff's suggestions about payment. First of all, the amount, $7,500 to $10,000, whatever that is, as well as a payment plan. Initially $5,000 up front, the rest being suspended until over a course of 2 years, they continue to meet the regulation. If I understood that correctly.
Yes, that's generally correct. Our suggestion, the $5,000 was a reference to a settlement offer that we made. Our suggestion is still $7,500 to $10,000 payment due, potentially under a payment plan with the remainder suspended.
Okay.
So
Some of you wise gentlemen or lady,
may I ask a question just to be clear? That would, the 7,500 to 10,000 range, that was sort of your proposed total penalty, and then there'd be a payment plan?
No, pardon me for not being clear. Our proposed total penalty is still the 18,402. That's our calculation based on what we think is generally required by the Act and the enforcement penalty policy and the rules. Our suggestion is that a penalty where payment is required and not suspended at all in the amount of 7,500 to 10,000 be issued by the commission, with the difference between that and the 18,402 as suspended.
If the operator remains in
Assuming
compliance.
compliance with the rules at issue for 2 years.
Okay, all right. And I'm still confused, so I'll shut up. Somebody else.
well, don't shut up yet. We're still entertaining motion. It's a conundrum.
Offer this. I think what I struggle with in this particular case, the operator has has brought themselves into compliance. It's tough for me that that ignorance of the law is no excuse, right? That they should have known to file the reports. Yet every dollar we fine is a dollar that could be applied to getting the well hooked up and generating a source of revenue. So, do you get creative and say, well, we're going to do the whole thing, but it goes into effect once the well's hooked up? I mean, that could take, as Commissioner Craig said, that we could be another 10 years or longer. Yeah.
We have a fair amount of leeway, I believe, Counselor. In fact, we could say, well, we'll accept the whatever, $7,500 fine, but we'd like to have it paid $1,000 within 30 days. The rest is going to be on a payment plan that you're going to negotiate. And then the other suspended amount will be based upon whether or not the company continues to stay in compliance. We have some options there, I'm suggesting to you.
Mr. Chair.
Commissioner Allward?
Thank you, Mr. Chair. I want to acknowledge, the work that staff has put in and how accommodating and understanding they've been in trying to work with this operator and recognizing how the operator has come into compliance. So I think looking at this 18,403, is that what I'm saying?
Two.
Sorry. I'm due for an eye test, right? That should be our penalty, and that the vast majority of that I see suspending, because I would anticipate continued compliance, and that's really what we want. It's not the money, it's the compliance. What I struggle with is what is a reasonable amount that, as Commissioner Benton said, we don't want to risk not, ensuring that this well never does go into production. And whether it, even 5,000 sounds like it could be a very significant amount. Whether $1,000, and this is where I think we really need to work on whether $1,000 due immediately, a certain amount in a payment plan that could be also suspended with compliance or deferred something, so that if there's one lapse, then the remaining amount is, due immediately, but then after 2 years, it would be knowledge that we've got an operator that's in compliance, which is what we want. So I think something like that of perhaps $1,000 if staff needs to work out a payment plan for that, and if there is a lapse, but it's a good faith that staff in working with the operator says, we're not going to call the whole 18,000, but we're going to call the remainder of that 5,000 in 30 days, and then continue on the 2 years for the remainder of that 18,000.
I didn't hear that in the form of a motion.
So I was actually putting it out there as something to discuss, but we can discuss it in terms of a motion. So a motion of $1,000 penalty that staff and the operator work out a payment plan if necessary. The remainder of that 5,000, so $4,000 that would be in any lapse, any failure to report or any other violation would be due in 30 days following staff's notifying the operator that there's been a lapse. And if during the remainder of the 2-year period, there is no violations. So I'm allowing for, if staff says this is a paperwork violation, we're not going to bring the whole $18,000 down.
You're going to allow the staff, the director, to have a fair amount of discretion in how to assess that.
Yeah, this is getting way too, I apologize for, I'm trying to accommodate the operator to the best that I can, but having two hammers there.
I think just to make it simple, I'd go ahead and just, I'd be in favor of approving staff's recommendation on the 18402 and suspend it, as long as the well stays in compliance. As soon as it's out of compliance, the whole thing goes.
Was that a motion?
Yeah.
Okay.
I'll second that.
I'll withdraw my attempt at a motion.
Okay. Okay, the motion has been made that we accept the staff's recommendation for the full penalty of $18,402, but to suspend it as long
I
as
seconded
the
that.
operator remains in compliance for 2 years. Is that correct?
Yep.
You heard the motion. Is there a second?
Yes.
And a second. Any further discussion? Hearing none. Those in favor indicate by saying aye.
Aye.
Opposed, nay?
Nay.
Okay, that motion passed. Hope you can live with that, Director. I know your staff did a lot of hard work on this, and I commend them for, and Mr. Black, for your efforts. For your efforts on behalf of the school children of Colorado. Cheap shot, I apologize for that. Okay, Director,
May I have an editorial comment, Mr. Chairman?
color commentator. Yes, sir.
Color commentator. Thank you. Absolutely, of course, this is your discretion, and I'm fine with where you've come out. I do want to tell you a little bit about how staff got to where we got, because these are difficult, and we struggle with them, and we spend a lot of time with them. And I was involved in the final settlement offers to do my best to give Black resources, in this particular instance, every opportunity. The other things that I know you are aware of, but that I feel the need to remind you is a lot of operators are struggling financially right now. A lot of operators fail to do their MIT tests on time, and a lot of operators do get NOAVs and pay penalties for not doing their NOAVs. So consistent treatment of similarly situated operators and similarly situated violations is an important part of this equation for us. I think Mr. Black's last offer back to us, give or take, you can correct me if I'm wrong, was $200. And in our estimation was inadequate, of course, or we would have accepted it. But when we look across the board at operators who, again, relatively similarly situated, there's no part of our rules that says certain rules do or don't apply depending on the economics. So I just want you to be aware that, we struggle with it too. There are a lot of moving parts, and in this case, we got to as reasonable as we could before bringing it to you. So I just want you to know that.
I appreciate those comments, and at least for me personally, I did in fact work that through my mind, because as a commission, we usually come down pretty hard on failure to conduct timely MITs. That's kind of been a big issue for us. And this is a bit of a departure from that. But I got the impression that these folks struggled pretty hard with that.
I agree. I understand that completely. The other thing that was at play here, in my own opinion, is the compliance history. And there are a lot of operators out there who would like staff to act as their executive assistants and help them complete paperwork. We've had these conversations about proper completion of forms, about ticklers. It's not our job to remind people that there are deadlines that they need to meet. There's 500 operators in the state, and there aren't that many of us. So those are the factors I just want you to be mindful of, that we were mindful of. Thank you.
I think we are duly chastised. Thank you. Thank you very much, gentlemen. We appreciate your. Okay, Ms. Murphy, I think we're at the Chris Glade Oil and Gas LLC. Docket number 1510004 8-3.
Yes, sir.
And I see Mr. Farron there at the table. Joined very quickly by Mr. Beckstrom. So, gentlemen.
Commissioners, I apologize for dashing your hopes if you thought you were going to have a brilliant Jeremy Farron presentation today.
That's what we're hoping for.
Instead, you get another one from me. Thank you. I've been told I speak too loudly, so I'm usually cautious about blowing people's eardrums out with the microphone.
Be sure to introduce yourself for the folks at home.
Okay, Commissioners, David Beckstrom, Enforcement Officer with the COGCC, here again, and I'm joined at council table by Jeremy Farron, also Enforcement Officer with the Commission. At this point, staff brings enforcement item docket number 151000483 against Chris Glade Oil and Gas, LLC. And for the record, I would ask it be noted that Chris Glade Oil and Gas LLC is not represented today. This case stems from violations at the Caris government well in Rio Blanco County, Colorado. This is a well that's operated on federal minerals and federal surface. It's a fed well, and it differs substantially from the well you just heard about, operated by Black Resources in a number of ways that we'll get into. So the violations that staff is bringing against Chris Glade Oil and Gas today is first, again, a violation of Rule 309. This is for Glade Oil and Gas's failure to submit Form 7s to the Commission from the Caris well, and also a violation of Rule 326, except in this instance, we have two different ways that rule was violated. The first is that Glade failed to conduct a mechanical integrity test on the well that was shut in within the 2-year allotted period. And the other way that this well is in violation of Rule 326 is that it has a demonstrated lack of mechanical integrity that has not been repaired. So a substantially different type of case than Black. Chris Glade Oil and Gas and its primary and owner, Chris Glade, was involved with this matter early on. We had been engaged in discussions regarding both settlement and compliance, as well as some of the initial steps of the pre-hearing matters. However, he has been disengaged for the past couple of weeks. We've heard no word from him. He has submitted no exhibits, offered no witness testimony or pre-hearing statement. And as you know, he is not here today. So in that regard, staff's going to do a quick presentation, give you a little bit of background, factual history about the well, the violations, as well as a recommendation for a proposed order that we will request the Commission adopt. Yes, Chairman Compton.
You feel highly confident that Mr. Glade was aware of this hearing?
We have been in the hearing officer and enforcement staff have been in contact with Mr. Glade through both telephone and email in the past. And the email address we have confirmed works, and he's received all notices from the hearing officer and follow-up emails from Commission staff.
Thank you.
Alerting him to the time and place. Oh, and also I would note that Jeremy Farron, I apologize, that the Chris Glade Oil and Gas late submitted stipulated facts in this matter that we received last week after sending him a hard copy of those in October. So we're not sure what's going on with him. Like I said, he's been disengaged with us. However, those stipulated facts were provided to you as a late amendment to the hearing packages and play an important role here because we received those, the violations and the factual bases for those have been stipulated to by the parties. And that's the extent of Chris Glade Oil and Gas's involvement with the hearing today. Yes, Commissioner Hawkins.
I have one quick question, and I should have asked this about the last case, but does this operator operate any producing wells in the state?
Chris Glade Oil and Gas does have 2 other wells, and they are both fed wells. One is reported as producing per Form 7s that were received this year. However, the reporting figures are questionable. And I can tell you, reaching back to Black Resources, the State 3611 well is Black Resources' only well that is not plugged and abandoned in the state. Of course. The Karis well, as I mentioned, is a fed well. It's located in Montezuma County, Rio Blanco County, in the far western portion of the state, just northwest of Rangeley. This well has produced sparsely in the last 15 years and has only reported production in 3 months since 1999. The well was taken over by Chris Glade in May 2011. He went out and did some work personally on the well in September 2011, and at that point discovered that there was a problem, that the well would not maintain pressure. At that point, he shut the well in and walked away. In December 2011, the BLM terminated his federal lease because there had been no production and he had failed to comply with the plug or produce order that they issued. That takes us to October 2014, when COGCC staff noted that the well was due for a mechanical integrity test. They issued a warning letter to that effect, requiring that Glade complete a successful mechanical integrity test no later than January 7th, 2015 as a corrective action. Glade failed to take any corrective action, failed to repair the well, and failed to conduct a mechanical integrity test by that date. So in June 2015, staff issued a notice of alleged violation, which brings us here today. The first claim is against Glade is a 352-day violation of Rule 309. This is for his failure to submit those Form 7s between May 2014 and June 2015. After receiving those notices of alleged violation, Glade did, in this instance, work with staff and submit those delinquent Form 7s on September 24th, 2015. However, since then, he has failed to submit additional Form 7s and is once again out of compliance with Rule 309. The second claim is a 454-day violation of Rule 326. Again, Glade has violated these rules in 2 different ways. The first is that the well was shut in officially in October 2011, and a mechanical integrity test was due on the well no later than October 2013, or within 2 years of shutting the well in. Glade failed to do this. The second way that Glade has violated Rule 326 is that lack of wellbore integrity. Glade discovered that the wellbore lacked mechanical integrity, or at least had reason to believe that it did, when it would not hold pressure when he did work in September 2011. Staff learned about this through conversations with Mr. Glade, and that led staff to investigate the well file to determine the exact status of the well and its mechanical integrity. Craig Berger, COGCC engineer for the Northwest, did a very thorough investigation into this well file to determine exactly what was happening. And it was determined through this well file review that the wellbore has lacked mechanical integrity since at least November 2010, though that could predate that, and that the prior operator to Glade was able to isolate the zone between 880 feet and 1,884 feet, that there is a hole in the casing in that zone, which lies in the Mancos Formation. It's worth noting that in their review, engineering staff did look at this and determined that although there is a lack of mechanical integrity, that there is no immediate threat of environmental harm resulting from this because of the unique geology and the location of the hole itself. And if you have any further questions in that regard, Stuart Ellsworth, COGCC engineering manager, is available for questions, although we did not call him as a witness since this was generally uncontested. So given those 2 violations, staff is asking for a total penalty of $66,636. This is calculated entirely under the new statute because this is an ongoing issue that has not been resolved, and because it is the severity of the issue itself requires a more comprehensive penalty. So the Rule 309, Form 7s is determined to be a Class 1 minor violation, a daily base penalty of $200 for 352 days. When the duration matrix is applied to that, that's a total penalty of $4,106. The second claim, Rule 326, the two different violations of that, we've consolidated into one because it's the same rule and the penalty is adequate to capture that. Working with engineering, because there's no direct threat to the environment from this lack of mechanical integrity as it stands now, it's been determined to be a Class 2 minor violation with a daily base penalty of $2,500. This has a penalty time frame of 454 days, which is calculated through today because the violation is ongoing. With that being said, the total penalty sought for this violation is $62,530, which brings us again to the total penalty of $66,636. This is the first level of remedy that the staff is requesting in response to these violations. Staff additionally requests that because there is a lack of mechanical integrity at this well, that the commission require Glade to repair or to temporarily, to plug and abandon the well no later than March 7th, 2015.
16,
sorry, I apologize. That being said, that date was calculated in conjunction with engineering staff to be a timeline they felt reasonable to get out there and perform the work as necessary. But staff, through its conversations with Glade, does not anticipate that Glade will be able to comply with that portion of the order, nor the monetary penalty that will be assessed. In light of this determination and anticipation that Glade will not be able to comply with the order, should it be approved, we like to go a little bit further. This was developed in conjunction with the BLM, as well as pretty comprehensive review by staff as an appropriate response given the unique circumstances of this case. In light of that, staff is asking that the order approved or adopted by the commission authorize but not require staff to declare this well orphaned, to revoke Glade's authorization to conduct oil and gas operations in Colorado, to work with the BLM to address the subject well, and finally, should it be necessary, to expend the environmental response funds to address the well, to plug and abandon it in accordance with COGCC operational priorities. We ask for this additional relief in light of the fact that we have every reason to believe Glade will not be able to comply with an order, which would leave this well in limbo of sorts. This is a summary of the these requests, and they're fully built out in the language at page 51 of your packages.
Can I ask a question?
you can make a motion if you'd like.
Well, before I can make a motion, I need to understand.
Oh,
I
okay.
need to understand something, okay? If in fact, as you expect, Glade is not going to go ahead and P&A the well and meet your deadline, to me, the logical step would be what you propose here. I mean, it strikes me if he can't do anything by March, that well needs to be P&A. Now, it says authorized but not obligated to. Are you trying to get the BLM to take responsibility? I don't understand. I mean, I guess I'm assuming that Mr. Glade does not respond. How am I going to get the well P&A as soon as possible after that date?
Of course, Commissioner Craig, I can speak to that, and I suspect Director Lepore may have some comments in addition to mine. But we have been working with the BLM. This is a fed well, and in fact, the COGCC has no financial assurance for this well.
Bingo.
Right.
It says so in the document.
Right. Okay. So with that in mind, we've worked hand in hand with the BLM on what the best course forward is. Our hopes, and through conversations with the BLM, is that the BLM will be able to address this well, that they will be able to plug and abandon it. However, we don't know how that's going to go, so we would like authorization to expend the ERF funds, if necessary, to address it should they not be able to.
are we putting a timeline on their ability to address this well? Or is it rather open-ended?
It's open-ended. Oh, sorry, this is Jeremy Farron, Enforcement Officer. It's open-ended for the fact that we just don't know. We want the flexibility. We don't want to have to return to you to get an order. We want to work with the BLM, see what can happen and how soon it can happen, but there's no time frames. It's as open-ended as possible. By
Mr. Chairman,
design.
may I?
Please.
Right, so BLM has the financial assurance, probably not adequate to do all of the work. As Mr. Beckstrom said, it's nice for us to have this authorization so that we don't have to come back to you. On the other hand, if we view this as really BLM's primary responsibility, I'm not sure I want expressly and explicitly to say COGCC is going to accept this liability. We have a line item in our budget for plugging and reclaiming abandoned wells of about $430,000 every year. We have more than enough wells on the list to go through that every year as it is. We prioritize those wells as we become aware of them based on our perception of their risk to everybody and everything. So we don't know where this well is on that priority list. It may be nowhere near the top. And therefore, even if we say, you know, it's our quote, our responsibility, it could be years before it gets to the top of the list because it's a dynamic list. A new one comes in, it's got problems, it jumps to the top. So we have this on all of these Fed situations, very similar situation. They have the bonding. You would think they would be the primary responsibility. We're trying to cooperate and push them along a little bit. But if we say, okay, it's ours, then, well, I don't have to explain much more than that. So this language has been crafted in such a way that we wouldn't have to come back to you if we made a decision that this well does get to that priority list. We would hope we would have access to the BLM financial assurance. That's not guaranteed. It's kind of a polite ask at this point. And then if we felt that it needed to be one of ours on the priorities from the PRA money, that's what we would do.
So the BLM has the financial assurance. If we revoke Glade's authorization to operate, and that would be for all wells in Colorado, then what happens to the financial assurance? I think that's what you were asked for here, is there's 3 wells total. I think I heard 3 wells.
So we wouldn't do that without consultation with BLM as to the remaining 2 wells, you know, what sort of impact, but we did ask for that authority to revoke it's their Form 1 and their Form 10, so essentially their right to operate in the state.
So then what happens to does that financial assurance that's with the BLM just sort of sits there in limbo, and then you ask that come to the state if we go ahead and obligate ourselves to plug the well? Is that how that works?
Like Matt said, it would be a polite ask from us to see if we could get those funds for our benefit, but there's no guarantee.
Yeah. And it's possible the BLM could undertake to say, well, it's on federal ground and federal minerals, so we'll undertake to be responsible for plugging and abandoning the wells per state. Okay.
And that's our hope, obviously.
Okay. The other question I had is, if you go back to the fine, and this is just to help me understand this in case things come up in the future, how did you arrive at $62,530?
So you begin by taking the class, so it's class 2, and then determining the impact level. So here, with consultation from engineering staff, we decided it's minor impact given the fact that we don't believe there's any environmental. You calculate that, you get a gross penalty, which is substantially higher than 66,000. yeah, normally they're pretty shocking. And then you take that number, and well, actually the amount of days, you plug it into the penalty policy, which has a duration matrix. So the penalty is at 100% for the first 10 days, and it drops off to some less than 100%, and it continues to decline. And so it's just a math formula, essentially.
That helps, thank you.
Commissioner Craig?
One more question. If we go ahead and keep this fine intact, as long as Glade has not paid the fine, does his restrictions to operate in the state, are they maintained?
Yes, they would be.
I think that's a given because the request is essentially to suspend those operations now. So put that in a motion, and then you're.
It's not immediate. It's upon failing to pay the penalty and failing to plug the well.
Commissioner Allward?
I just wanted to say that I don't think I could support a motion that had us authorize expenditure of our funds at this time. I would want staff to come back. I kind of think that it's something staff could use to encourage BLM in their polite request that they don't yet have authorization to expend state dollars. So I think that should be something that we don't have, or that I would find very difficult to support. I'd be open to persuasion.
Before you get persuaded, my tendency is to agree with you. I actually had that same thought, but I was looking at the director to seeing if that was going to be
So you
more.
want your motion to be this penalty and that March 7th deadline with staff coming back?
If we went
After
back to
March.
the your last slide, of course. So I'd be open to the motion to be the penalty, and the items, first three items on this, directing staff to work with BLM, and if they don't comply, to revoke their authorization and all that, but that staff would be required to come back to us if they wanted to expend money.
I can second that. Yeah, that's good.
Oh, wait a minute. We have a motion
Yes.
and a second.
Before we vote, could I,
You want discussion?
just a short.
Yes, sir.
I guess this kind of comes down to, do we really expect Glade to have any response to us anymore? Because, yeah,
No, we don't.
so.
Further discussion.
Yeah, so that's where I am on this, is that he's not responsive. To me, it sort of gets to, it's a formality that we're going to impose a fine and you have a certain length of time to comply. Why not dispense with that and let's just move on and revoke the authorization to conduct operations? Can we do that?
Well, no, I'm going to ask council. I would assume we need to give them,
Do we have to give him, are we required to give him the notice? If we're fairly confident that nothing's going to happen?
I'm a little nervous in the back of my mind, I'm thinking there might be a statutory requirement, and it's also been our habit to give them the 30 days regardless.
I'm not worried about the habit, but we need to make sure there's not some statutory obligation for a period of time.
Whether there is or not, I think you need to make a final demand to the operator and let him know that this is it. You know, either he pays up by a date certain and performs these activities, otherwise he's done.
And correct me if I'm wrong, but I would think that would be the order that would issue. The order would say, if this doesn't happen by this date, then this happens.
Is there any incentive to offer to him, if he were to plug and abandon the well, that we would suspend the penalty?
We discussed that in settlement negotiations, and he said to us that he would be unable to raise funds to plug and abandon the well, which is really his only option at this point. And given the BLM stance that this well needs to be plugged and abandoned, given the engineering stance that this well needs to be plugged, we don't think that he'll be able to do either pay the penalty nor plug and abandon the well.
We have a motion and a second, and we've had discussion. The question has been called. Those in favor indicate by saying aye. Aye. Those opposed, nay. Thank you, gentlemen. Very good. Are you going to yell at us some more?
Just to confirm, you essentially struck paragraph G from the proposed order, which was the expend funds without coming back to you.
Yes, sir.
Thank you.
Thank you, Commissioners.
Ms. Murphy, I'm at a total loss now. We might just as well do lunch, and you want to work during lunch, I understand.
That's correct. I believe Mr. Mueller is here and can give us a presentation while we eat. And then it's at your discretion to.
Okay, so how about a 10-minute break to gather your lunch? And Mr. Mueller gets set up and we'll proceed. You leaving?
No, just sorry about all the Fuhrer. Jake's wife's baby is in some distress, and he had to find them to bring to the hospital.
Oh, goodness.
Yeah, she's like in her third trimester. Yeah, so they were.
That's a bad timing.
Yeah, it is.
Well, it's bad timing for his wife.
Well, yeah, this is an argument tomorrow. I think we're probably going to find a backup.
Does the Supremes allow that?
Yeah.
Or they give a continuance sort of thing?
No, I think there's a couple people.
Okay. All right. How many of you are there? I mean, it just seems like we're overwhelmed with Attorney General.
Out of the woodwork.
Can we talk about tomorrow?
Yeah.
Oh, could Matt do it? That'd be cool.
No, sir.
and also to some of the issues that are obviously facing the state of Colorado right now. The CDPHE gas venting regulations that were adopted in 2004 allow operators to flare or incinerate oil storage tank flash gas or recover it. That's really the two options that are given. No longer venting it, but you can either burn it or recover it. However, and this is a key thing that the folks that tried some early technology to make this happen, they found that the oxygen contamination limited the prevention of that flash gas because the pipelines right now, like CIG, their standard is 10 parts per million of oxygen. And you may be aware that last September, DCP had to blow down a large part of their system because of the amount of oxygen that was coming into their system from tank-mounted VRUs. It was a bad day for DCP. What we've done is focused on there's a lot of different VRUs, vapor recovery units, that are in process right now. Some of the brand names are High Bond and Phlogistics, but they've avoided the tanks because of this oxygen issue. I guess as in the spirit of, I know there's several mines graduates here that, we seem to swim upstream sometimes. That's where we went. And so we're focused on the tanks and oxygen conversion technology. The benefit of obviously recovering it instead of just burning it on site is a 90% reduction in the emissions on the sites, and also a lowering of tank pressure, which is another way of reducing emissions. And what we're using the term is unplanned emission events. I want Hans to take it through the technical stuff. I'll take it over back when we get to the economics and some of the benefits of to Colorado.
Thank you, Commissioners. I want to be cognizant of everybody's time. I know that you guys have had plenty of fun the past couple days, and I don't want to bore anybody with a in-depth, detailed engineering analysis of what it is that we do. So I'll try and boil it down to a few highlights. What we have up on the screen is a process flow diagram for a typical well site. We have removed some of the complexities, perhaps a low pressure separator, other vapor recovery equipment upstream of the oil tanks. But what we did want to highlight was our system and how it integrates with the rest of the operations on a production location. After everything goes through a three-phase separator, gas is delivered to the gathering line, while oil ends up in the oil or the condensate tank battery. All the other vapor recovery technologies occur upstream of the tanks, so they're good at getting a lot of the vapor before it does reach the tanks, but not all of it. The tank battery really is the best separator on location in terms of resonance time, surface area. It also operates at the lowest pressure, so that means that this is really the final stop for the train. This is where all of the gas that hasn't already broken out a solution will. And this is why control up to 95% control is mandated. What makes this technology novel is that the tie-in happens at a minimal cost with minimal effort. Rather than having to set an additional separator or a vapor recovery tower in conjunction with the compression equipment, all we require is to tee off of an existing line that heads over to the BOC burners or the flare bank. So whether it's retrofitting existing locations or planned into new locations, capital cost is almost zero. It just requires a couple pieces of pipe to plumb it in. When we started out, we also recognized from an operational perspective, had we asked operators to change the way that they were doing things to bend essentially to a new method of operations around our equipment, that just wasn't going to work. So we've designed it in a way that it exists on the location in a way that when it's operating, the flares are completely dormant. There's essentially no emissions coming off of the production location. When there is an upset, if there's a problem with our equipment, it's like it was never even there. Gas is automatically routed to the flares, as is the status quo today. The parts of the technology that are novel really can be boiled down into two parts. Oxygen removal. We can purify the stream coming out of the headspace of the tank battery to the point where it will meet gathering line specifications. All oxygen is actively removed, and the process is monitored in a way to make sure that it's reliable. No oxygen is delivered, and we have actually confirmation from DCP in the DJ Basin weekly that they haven't seen anything from our equipment. We're not the cause of the problem that they had last September. The second aspect of our technology that is new is the level of precision for which we can control the pressure of the tank battery itself. This is a big deal from a safety standpoint as well as environmental. If we're able to collect everything inside the tanks to the point where that pressure is managed, it's actually managed down to a 64th of a PSI, which is a couple of orders of magnitude more precise than other technologies like varying the speed of the compressor to try and keep up. Again, I don't want to bore you with too much detail, but that's really what it comes down to is management of tank pressure in the condensate tank battery, as well as the ability to purify that gas to sales specifications. That's really what facilitates our ability to get it all. This is a 24-hour snapshot of our oxygen destruction reactor and how it operates. Green is just showing that the unit was operating for the full 24-hour span. Orange indicates the oxygen concentration at the inlet of our system. This is the amount of O2 present in the headspace of the tanks. Red down at the bottom shows the oxygen level coming out of our reactor. This is on our system's discharge. Essentially what the reactor is it's very similar to a catalytic converter on your automobile. Those have been mandated and in place since the 70s. The only difference is that instead of burning off a little bit of unburned hydrocarbons coming out the exhaust pipe, we just have a little bit of oxygen and plenty of fuel. So the same concept applies, that if you get that mixture to the right temperature and run it across the catalyst, the oxygen or the fuel will be combusted. So that's what's happening on this chart. The blue is the inlet temperature for our reactor. The pink or purple is the outlet temperature of the reactor. And you can see in the morning until about 6:30 a.m. or so, oxygen levels in the tank battery were rather minimal. But when an oil hauler showed up, opened up the thief hatch, removed a load of oil from the tank battery, that volume was replaced with air. This is where the oxygen is coming from, and you can see that dramatic spike. It goes up to over 12,000 parts per million, or 1,200 times the allowable specification that gathering lines will accept. And you can see that after that event, that crude sales event, the temperatures of the reactor invert. Instead of losing heat to ambient, now it's generating its own heat by actually burning the oxygen. This is really just evidence that the process is working. And as oxygen levels decrease, as air is pushed out and removed from the tank battery, you can see that concentration declines. So does our outlet temperature of the reactor. Same exact process happens again in the middle of the day or towards that afternoon, where more oxygen is introduced. But the takeaway from this chart is just to say that really for the majority of the day, about 3/4 of it, that gas in the headspace of the tanks could not be recovered to specification until it's treated and processed, having the oxygen removed. Any questions before I go on?
You occasionally, let's go ahead. I'll.
Okay.
One more.
Go back.
One more forward. So this is the second part of the technology where I was talking about our ability to control pressure inside the tank battery itself. The green line is represents 4 ounces on the tank battery. We typically outfit the burners with a valve that only allows pressure above 4 ounces to move to the burners. So anything above that green line is gas being flared. Anything below that green line is gas being recovered in its entirety. The burners are dormant. Everything on the production location is now being sent to sales. Typically, pressure is maintained well below the 2 ounce level. In fact, typically about ½ an ounce. But those spikes, those instantaneous spikes, they last only maybe a minute. That's usually when the separator will dump that high pressure, those high pressure liquids to the tanks, and you'll see a bunch of propanes, et cetera, evaporating out of the solution. So our system manages that and brings the pressure back down to where we set it to. On the right-hand side of that black line is what things look like without our system attached. We'd put it down for maintenance. We had some work to do in the morning, wanted everything to cool off. Tank pressure jumped because burners are inherently passive in their ability to manage tank pressure, and well, a lot of gas was being burned at that point.
So, a couple of the hearings ago, we saw a presentation by an operator which they're essentially going to tanks, pressurized tanks with no detach. Assuming they're going to run at a slightly higher pressure, is this system capable of saying, okay, your set point might be under 10 ounces or something like that? You can operate that as well.
That's a good question, Commissioner. The answer is absolutely. The harder thing to do is to operate at those pressures that are extremely low, extremely close to ambient. It only becomes easier for the system to operate if at an elevated pressure. And I believe we're in communication with potentially that group that spoke here earlier, and they see that the ability to capture the gas, even though they've figured out how to keep the hatches closed, they still recognize that once oxygen is in that tank space, it's not going anywhere. It's not Caesar salad dressing that we're dealing with, so they don't even recover it, even though they do seal their hatches. But because of the oxygen removal technology, they're now confident that they could recover it.
These were actually tanks with no detach at all.
Okay.
And I haven't forgotten, I owe you that.
All right, that's good.
You go back one. Yeah. From an overall emissions standpoint, this is what things are going to look like from moving from flaring to capturing everything. Had we shown the data for what emissions would look like, both for VOCs, carbon monoxide, and NOx, it would be probably a couple stories tall if we showed what it would look like without flaring. But flaring is definitely a huge advancement from where we were at a decade ago. We're down to essentially 29 tons per year if we're flaring 60 MCF a day. That's 95% reduction. We can further reduce it another 95% at least. With tank vapor recovery, those emissions levels drop from 29 tons per year down to 2.7. And what's not captured in the 29 tons per year is the amount of carbon dioxide that is going into the air, currently unregulated, but certainly in existence. If you're not burning it, you're not introducing that stream either. That 2.7 tons does include the exhaust emissions from our natural gas engines that drive the whole thing.
One thing I'd like to point out is there's a box on there that says it's modeled on 60 MCF a day of 2,800 BTU gas. This is, the gas that's being flared is the best stuff on location from a hydrocarbon point of view. We've seen 2,800 BTU gas. We've seen as low as 2,200 BTU gas. We've seen as high as 3,600 BTU gas. And even at today's prices, this gas stream is still worth about $15 an MCF. And it's the other thing that's interesting is as we've talked to more and more operators, our initial assessment was that about 5 to 7% of the gas being developed on location was being vented. COGCC their opinion is that it's more along the lines of 10 to 15%. Not vented, my apologies, being incinerated on location, but essentially put to no use. Here's the evaluation. And on the left-hand side, these are product prices. This is last month. On the right-hand side is the gas composition. Again, as I mentioned, we've seen gas down to 2,200 and up to 3,600. We took this is real data off of a sample at 2,800. And you can see that the composition to the right, bottom line is, on the right-hand side is 24 GPM gas. So it's almost a half a barrel per MCF on that. On the left-hand side, we have three sizes of units, a 30, a 70, and a 170. That's the amount of gross production or gross gas capacity we can move through there. And we don't have the 30 showing on here. We do have the 70 and the 170. When you look at the numbers on the left-hand side, system capacity is 72, runtime to sales 70%. We guarantee 95, but we know that truck loading time, things happen, whatever it is. We like to be conservative in our numbers, so we put in a 70% runtime to sales. You can see the gross recovered gas value about 26 grand. We just, for illustrative purposes, take a 50% haircut off of that for 20% royalty. That may be low in some places right now, and 30% processing fees. Take off the lease cost of our unit. And there's still leaves 6 grand in there for the operator, even at current prices. Obviously, construction or build costs are not linear, so the larger systems look even better. 170 MCFD, again, the same runtime to sales. The value of the gas going up in flames is 63,000. These are monthly numbers, by the way. And so take off half that and 31,000, higher lease cost for that still leaves about 19 grand or so. Point of this is that during the period of time when a location is relatively new, has new wells on it, and there's a lot of flash gas coming off, this gas is economic to recover. When we look at a couple of other parameters as far as emissions going, I put this slide together a couple weeks ago. There were 28 rigs operating in the DJ. A well per rig per week. That's the assumption I started with. That's almost 100 wells per month. A lot of operators are now putting 8 wells per pad into their facilities. Flash gas per pad, I estimated at 60 MCF a day. And you can go through the numbers there. Basically, you get down to tons per year. VOCs uncontrolled would be about 100,000 or so. You put the combustor on site, take that 95 or 96% reduction, it drops it dramatically. And again, the combustors were the right thing to do, no question about it. And it drops that down to about 4,300 or so. Take that and recover that flash gas, you drop it another 90%. And so when you compare that reduction, the total reduction to what it would have been back prior to the 2004 CDPHE rule, that's almost 100, well, obviously 99.6% reduction. So when we look at flash gas values in the DJ Basin alone, flash gas added per year almost 8.8 million a day. Again, using 2,800 BTU gas, you can range that as you want to. The value of that flash gas is about 48 million bucks. You look at royalty. I'm sorry? That was 250. But again, the gas price, interestingly enough, because of the very rich nature of this gas, is not a big driver for the value. It's really the value of the NGLs that makes the difference. Royalty value, you can see 6 million, ad valorem 5, county taxes another 5, and so on down the line. Total value to Colorado is about 20 million or so, looking at both public and private side. And basically, bottom line is the cost to implement is zero. That's, these are rented or leased units. There's no CapEx involved. This is something I like to look at. And when you look at resource conservation, again, what's the highest and best purpose for this? We talk about 2,800 BTU gas. The gas coming into this building is about 900 BTU. It's slightly cut with air by our local utility. And so this is rich stuff. It goes a long way. And one of the things we also want to do is we want to thank Noble Energy for their support. They were really the initial leader in helping us put this out and giving us the opportunity to give this a try. Noble's been great, a great partner. We add up the volume of gas we recovered for them. Gen 1 and Gen 2 are just the models of units that we've developed. I can't stop this guy from developing new stuff, so he's on Gen 3 right now. And I know he's got Gen 4 in mind. It only takes time and money. So the Gen 2 was 130,000 total altogether. We also worked with Newfield and Bayswater, almost 950,000 MCF. Again, you translate that through the number of homes in Colorado that get heated. We're almost at 40,000 so far, and that number grows every day. So we're very proud of that, and directing this gas that would have just gone to no use to putting it down the pipeline where it can be used. So, again, we look at this as being something that is in line with the Oil and Gas Commission's mission as far as the efficient production and prevention of waste and the prevention and mitigation of adverse environmental impacts. We think it's good stuff. We're glad that we've had the support of operators here in the state. We know that we're not the only technology to reduce this, but as far as being able to recover gas off the tanks, I think we're leading the way.
Thank you for your time.
Thank you. Very interesting.
Thanks very much.
Don't run off.
Okay.
There are 2 or 3 engineers on this commission that I know are burning with questions.
Yeah. Darn engineers.
Couple, unless you would like to go first.
No, you go ahead. I'm taking notes.
I think you mentioned it was, if you use a catalyst, you have to replace that.
As long as we're able to protect it from sulfur introduction, theoretically never. We're seeing actually about 3 years is closer to reality. In fields with hydrogen sulfide present, what we do is treat it beforehand, before it gets to our palladium catalyst. The palladium catalyst is completely regenerative. It's not used up in the process. It just can get poisoned if it's contaminated with sulfur. So
What's your limit on sulfur H2S?
Historically, it's been about 15 to 20 parts per million. I just completed a project where we opened that up to about 250 to 300 parts per million. So it's definitely one thing to state about our technology is that it's certainly not applicable everywhere. It's not going to make sense in every situation, but when the application fits, we can provide zero emissions well sites at a profit to the operators in the state.
Although if you notice if you had enough gas volume, even if it was sour,
Right.
you could scrub that, run it through a fire pump or something.
Exactly.
Scrub that out and then run it through the sealer.
Yep.
So, and one of the, I guess, question I would have on this is flaring does reduce the amount of VOCs and everything else we put into the atmosphere.
Absolutely.
I'm curious about one of the things we hear a lot about is odors and smells and so on and so forth. What level of odoriferous emissions do you have out of this system?
Well, we
do our units stink?
No, the way I'd answer that question, how what impacts to the environment, whether it smells, noise, anything else. In terms of the odoriferous aspect, we are trading, when we deploy on a location, we trade all the gas that would be coming out of the thief hatches, if it's during a crude sales event or thieving or gauging operations. Those hatches are just open, and all those vapors are coming out uncontrolled into the environment. It's not uncommon to get complaints from neighbors downwind when that happens. If all that gas is being recovered, and I mean all of it, then there's nothing to cause those complaints. The trade-off is the exhaust that's coming out of our 25 to 50 horsepower, depending on the model, natural gas internal combustion engine. They're all EPA certified for off-highway use, all emissionized. That's why we're able to confidently say that comparatively the emissions are reduced that much, and that second figure does include everything that's coming out of the exhaust pipe. Also, we've designed to meet and actually exceed the COGCC's Series 80 noise requirements, even in rural areas during nighttime. Our engines are absolutely the most quiet ones on location. This is me getting into some detail here, but when we have to heat the gas up post compression to get the reaction that removes the oxygen to light off, what we're doing is we're routing the exhaust from the internal combustion engine into a heat exchanger, an insulated heat exchanger, which acts as a phenomenal muffler. And then we put in some cases where necessary, a hospital grade muffler on after that. So we are by far and away the quietest engines on location. I hope that answers your question.
No, it does. And, mostly the economics you present here are fairly attractive for an operator. So why are they keeping the doors down?
Well, we've spent a long time in actually kind of black box R&D mode where we're actively not selling our products. This really went from proof of concept to a commercialized offering late last year. The combination of operators having other things to worry about with the fall of commodity prices, I think was one effect. But as regulations continue to go in one direction, as well as the operators' new mode that they've landed on in terms of trying to be as efficient as possible to do, to use every part of the buffalo essentially, they are calling us. And one other thing I'd add is that my business partner has spent 37 years on the other side of the table for me as a oil and gas producer and operator. But bringing him into EcoVapor's business has really helped us with an outward look. So I think that what's happening is that we are expanding with current and new customers.
Obviously, some challenges in technology.
Yep.
Get that out there. From an economic standpoint, it would make sense.
In the right application, absolutely. We think so.
Is the 30 MCFD unit positive net rev to operator after ERS lease? That one to me looks like it'd be close to break even.
It's tighter. It's tighter, and certainly the applications are more limited for it. But what we've tried to do is kind of offer the Goldilocks suite, small, medium, and large, depending. And as Peter mentioned earlier, costs of production, costs of packaging, manufacturing, they don't scale linearly. So the economics, it is true to say that the economics for a larger system will be more attractive, but in places where there's not enough gas to justify the higher lease rate that would come with a larger unit, that's where we offer the smaller ones. Mm-hmm. And also during the decline of production, some operators that we worked with have said, hey, let's, great, they offer small, medium, large. Let's just start with the big one, move to the medium, and small as time progresses. Others have said, hey, why don't we just stack a couple of them in parallel? They work very well together in parallel. Maybe it's just easier to pick one off at the appropriate time, but that's really our customer's preference. Everybody seems to do things a little differently.
How many systems do you have operating now?
We are fully sold out. 35 are turning at the moment, and we're building more as we speak. And we're also coming out with a new generation of unit that hopefully, well, not hopefully, will significantly reduce the cost of production and therefore the rental rate as well, making the economics only more attractive.
Have you been looking at other states, I'm sure other application areas?
We are operating currently outside of Colorado. We actually have the majority of our capacity is deployed south of Oklahoma City in the Scoop. And we expect to be going into the Eagle Ford with a couple different companies that are asking us to in 2016. Bakken also is an attractive one for us, but
Has H2S?
yep, but we're working on removing that on the front end so that it never touches our skid.
Yeah, because you have a problem with that in Eagle Ford, right? I mean, there's H2S in Eagle Ford.
There will be, and we've actually partnered with a group. Huh?
Are you working with EOG?
Not directly with EOG at this time. We're going to be going out with BP and Occidental here in the first quarter of next year. Probably some others too, but we're not yet to the point with them where I can confidently say that that's going to happen when. So, but we do think that, this has been an issue for the industry for a while. What are we going to do with all this gas? We certainly weren't the first ones to say, man, it would make sense to recover it. The value's there, and it didn't happen overnight, and it actually happened the hard way in a few instances. But we developed a solution to those problems by being able to treat the gas and condition it to the point where the midstream companies will accept it, and also make sure that we line out nicely with existing operations for the producer. So.
You mentioned CO2. You made any attempt to estimate the amount of tons per year of CO2 to take away by not flaring the gas?
We have.
Don't need the number, but I was just curious.
We have actually had that modeled, and the numbers are pretty big. And so before I'm having them QC'd one more time by a different group to make sure. It's quite a bit. My last comment is this is a technology right now that, again, is being on the second generation and now heading into the third generation of these units. Part of our goal is to make them simpler and more reliable and reduce the cost. By reducing the cost, we can also expand the number of sites that they can be deployed on where they make economic sense. These make sense for, economically at least, for certain sites at a certain time in their production life early on. This is not a solution at this point for all wells all the time. I don't want to oversell it. I don't want anybody to get that impression. But certainly during the early time, and it's fascinating talking to different operators as to what that means. There are some sites in the near Greeley that looks like we'll be on for a long time. There's a lot of flash gas coming off that oil.
Did you do this? I think, John, you told me this. Was this part of your thesis at Mines?
My senior design project at Colorado School of Mines involved flare gas capture off of landfill locations.
Okay.
But the problems we ran into there were both inherently economic and operational in nature. The gas coming out of a pile of garbage is also full of garbage. Siloxanes will destroy your rotating equipment quickly. And then the second question was, okay, what do we do with it now? There's no gathering system on location typically. You could always, in some cases we're heating soccer fields on top of landfills. All these things make sense, but from an economic standpoint, turning a generator and getting 7 cents per kilowatt hour to feed into the grid won't justify the cost to build this equipment. However, immediately after graduation, I looked north and saw that, hey, the gathering system's right there. Gas quality went from the worst to the best that anybody's ever heard of. 3,400, 3,500, 3,600 BTU gas, I don't know where else to find it. So that was solved. And then all that remained was a technology hurdle for being able to meet sales specifications and also make sure that we don't pull a vacuum on the tank battery and manage that pressure to an ideal spot from both, well, I guess, economic, environmental, and safety standpoints. So,
Excel will only give you 7 cents?
When I was running the numbers back in 2009, yeah.
They're totally theoretical, but the COGCC sponsors a project to collect gas from seeps, natural seeps.
Sure.
And they've had a little tiny problem with oxygen in it.
Yeah, it's not surprising to me. I think that for coal bed methane applications, this is a perfect fit as well.
You're working with BP, you said.
Yeah, on some of their Eagleford stuff. Lower, BP lower 48.
And we've also talked to BP about some applications in the San Juan.
Very interesting.
Imagine royalty owners would be real happy that they're selling gas instead of flaring.
Well, I think so. I don't want to put words in their mouth, but it would make sense. Speaking frankly, it's been, there really hasn't been any reason that anyone's pointed out as to why we wouldn't do this, other than it does take doing it. We've minimized the tie-in. The capital cost is negligible. Literally, we're the ones that pick up our skids and deliver it to the next location. All we ask the operators to do is to pipe it in, and we don't even require a separate vessel like all other vapor recovery technologies do. But it does take doing it. It does take recognizing that, at the end of the day, if we're able to eliminate emissions and generate a profit for the state, the royalty owners, as you called out, the Colorado citizens, that EcoVapor employees, as well as the operator, our customer, then I don't know what's wrong, or why people wouldn't. So it's a new technology, and like I said, we spent a lot of time actively not selling it, but we're confident in our product now, and it's tested. We have 35 of them operating right now, with the midstream gatherer's blessing to do so. They also believe in our ability to deliver gas to specification. So.
Commissioner King.
Thank you, Mr. Chairman. Apologize for getting there early, but the Chairman Compton is much more efficient than previous chairmen have been, so.
Whoa.
I'm just having fun with Peter. We
get that out of my back.
When Peter first came to me, what was it, 2.5 years ago,
Yeah.
This was kind of a head slapper. It was like, how can this not be where we're headed? And then we saw CDPHE with their methane rule and all the heightened standards that we have. And this is, as they point out, just the only downside is it's change, right? And it's even an industry that is as innovative as the oil and gas industry, it's changed, and that's hard. And there are accounting issues. I mean, you guys had technical issues about getting the oxygen out, and then they were running into royalty problems because industry didn't want to deal with having the accounting issues of having all of this. And you were just thinking, this cannot be stopped because of accounting issues, right? Understanding that everybody's going to get more, and yet we're not able to get there. So I want to thank Peter and Hans for coming in and giving us this presentation. I really think it's the wave of the future, and I think we're going to see more and more of these types of things. And so good stuff. Appreciate all the work you're doing.
Thank you very much. Thank you all.
Thanks again for the presentation.
You bet. And except for that comment.
Thank you. If the shoe fits, you'll wear it, Bill. Okay, I can't find a single other item on this agenda.
I'd be happy to start making some up for you. No?
Commissioner?
Move adjourn.
Oh, no.
Council's not here to help me out, but I don't think I need a motion to adjourn.
I don't think you do, but now that she's recording it in the minutes.
All in favor of adjournment, say aye.
Aye.
We are adjourned. Thank you. Thank you all very much.